And secondly, as we all know, the federal government does not enforce whatever statutes that it may have in law, except for rare cases. It states to them, that they don't, the federal agents are not going to come in here to enforce it within our state boundaries. And as we've learned with wildlife trafficking and the flame retardants and other bills that are consumer protections, that we need to have the statutory language on the books so that it can be possible enforcement here. Across the country, states are passing these bills. They are kind of cognate with each other. The most recently was New Jersey, I believe December 21st of 2021. That law was signed. That bill was signed into law. 8 others, and I suspect that we will soon see almost all the states have come to the understanding they need to do as well to get something in state statute. So that's the bill. It has a very strong support, as you see, from our colleagues, and we've always, in this body, tried to be, very cognizant of animals and doing what we can to outlaw practices that we recognize as cruel and unnecessary treatment of animals. So thank you, Mr. Chairman.
Thank you. Questions? I'll go first. Thank you. Thank you. Senator, where are most of these cosmetics produced? Overseas or in the United States?
I wouldn't know the answer to those percentages. I mean, it's a huge international business, right? And I imagine that manufacturing and testing flows as most manufacturing does, and perhaps representatives from the ASPCA behind me would have more indication of that. I will say, and thank you for your question, but I will say that, wherever they're from, this is one reason why we need statutory enforcement authority within state law. Because
and how would we know if they were produced in China, whether they were tested on animals or not?
Well, that's the job of the federal government, in large part, to determine these things. And you'll see the federal statutes that are mentioned and the FDA and other things as well. I mean, we all know this is hard to chase down, right? Yeah. But when something becomes known, then it's important we have authority in state statutes so the penalties here can be undertaken. And the manufacturer would know that. You know what I'm saying?
Right.
They know there's going to be real consequences to doing what they do.
Yep. Thank you. Senator Gannon?
Thank you. Thank you, Senator, for taking my question. What percent do you know of the industry or animal testing? What percent? Is it like 5% still do this? Is it 95? I'm wondering, is it a problem? How big of a problem is it?
Yeah, I don't know percentages.
Okay.
And thank you for the question, but in some ways, do we put a percentage number on the amount of suffering and cruelty that is done? And I think that again, without going into the details, we have seen the kind of cruelty that's inflicted on dogs and on rabbits and other mammals who may have biological systems that would make them targets for such testing. So, I mean, perhaps there'll be some answer to that following me.
Yeah, anyone else answering, if they could tell me later, that'd be great. So if I'm Estee Lauder, Revlon, any of these cosmetic companies, I certainly don't want to spend money on animal testing. I talked to a Canadian company last week who had contacted all of us. And why would I want to spend money on animal testing if it's no longer necessary? So I'm wondering, someone else might follow up, why would Revlon? We'll just pick them or Estee Lauder or anyone. Why would you spend the money? And it's also going to be bad press. All the young people, they're twittering, they're going to send out, is the market taking care of this on their own? Or is this a big problem still?
Thank you for the question. I'll point you to page 2 of the bill. And you will particularly notice that there are provisions here which address just what you're talking about, that if there is no non-animal alternative method, if testing is requested, required, or conducted by federal, state, regulatory authority, and each of the following apply, that there are these circumstances where, we balance these things, that there may be moments when sometimes some things do need to be tested on animals. I think what's important here and what the statutory and regulatory authority that's noted on this page of there is there needs to be a careful process about that. And so what the enforcement here says that, okay, it is possible, but we know this is an industry that for decades we know that there was abuse, right? And that there was no reason for them really to do other than go to the cheapest method or the tried and true method without recognition of the suffering that it was caused.
Thank you,
So,
Senator.
thank you.
Any other questions? Thank you, Senator.
Thank you, and I have to go to another, to
Oh,
energy and natural resources, so, thank you.
Have a fun morning.
And Kurt Ehrenberg?
Good morning, Chairman French, members of the committee. I'm Kurt Ehrenberg. I'm the State Director of the Humane Society of the United States here in New Hampshire. It's an honor and pleasure to be before you this morning. The Humane Society of the United States supports this legislation. I think you have my written testimony. I also have provided you with letters from 4 New Hampshire companies that support this legislation that are in the cosmetics industry. I appreciate the opportunity to submit this testimony on behalf of the Humane Society of the United States and our New Hampshire members and supporters, urging the committee to pass Senate Bill 202. This legislation prohibits the sale in New Hampshire of any cosmetic for which a new animal test was conducted or contracted by, on or behalf of, the manufacturer or any supplier of the manufacturer after January 1st, 2023. SB 202 SB 202 does contain limited exemptions that allow for animal testing under certain conditions, including testing done to satisfy regulatory requirements and to address specific and serious human health concerns. There is strong corporate support for ending cosmetics and animal testing, and this bill has received letters of support, as I mentioned, from a number of New Hampshire companies. Good morning, Senator Bradley. Kurt Ehrenberg with the Humane Society of the United States, testifying on a bill that you are a sponsor of, and thank you as well to Senator Kavanaugh for being a sponsor of this legislation. Federal legislators are currently considering the Humane Cosmetics Act bipartisan legislation to end the production and sale of animal-tested cosmetics. HSUS, the Humane Society Legislative Fund, and the Personal Care Products Council, the leading national trade association representing 90% of the U.S. cosmetics industry, joined together to support the legislation in an unprecedented agreement to bring about an end to cosmetic animal testing in the United States. In addition to PCPC, which represents approximately 600 member companies, 370 individual companies have endorsed this federal effort. SB 202 was drafted to mirror the provisions found in this federal legislation. Animal testing is cruel and not a reliable predictor of human responses. This is important because it's cruel and it's also totally unnecessary. In traditional animal tests, rabbits, guinea pigs, mice, and rats have substances forced down their throats, dripped into their eyes, or smeared into their skin before they are killed. These test methods are unreliable predictors of human safety. Different species can respond differently when exposed to the same chemicals. Consequently, animal tests may under or overestimate real-world hazards to people. In addition, results from animal tests can be quite variable and difficult to interpret. Animal testing for cosmetics is completely unnecessary. We just went over that, but there are no animal testing requirements for cosmetic safety substantiation in the United States. Companies can already create great products using thousands of available ingredients that have a history of safe use and do not require new testing. For new ingredients where animal testing may currently be used, many non-animal methods have been and continue to be developed. Non-animal methods can combine human cell-based tests and sophisticated computer models to deliver human-relevant results at less cost and in less time than traditional animal tests. So there's many, many reasons. And probably hard to find a good reason to continue these inhumane practices. Last, there's been a global trend towards eliminating cosmetic animal testing. In 2018, California became the first state in the country to ban the sale of cosmetics newly tested on animals, followed by Nevada, Illinois, and 5 additional states have passed laws to prohibit the sale of animal-tested cosmetics. They are Virginia, Maryland, Maine, Hawaii, and New Jersey. Historically, the European Union began the trend in 2013 by finalizing a ban on the sale of cosmetics tested on animals, creating the world's largest cruelty-free cosmetics marketplace. This ban compelled cosmetic companies around the world to end animal testing and invest in the development of non-animal methods instead. 41 countries have now passed laws to end or limit cosmetic animal testing, including the member states of the EU, Australia, Colombia, Guatemala, Iceland, India, Israel, Mexico, New Zealand, Norway, South Korea, Switzerland, Taiwan, Turkey, and the United Kingdom. HSUS strongly supports SB 202 and urges the committee to pass this legislation to make New Hampshire the next state to address the unnecessary cruelty of cosmetics animal testing. Thank you. Glad to take any questions.
Thank you. Senator Susi.
Thank you. You mentioned that this legislation mirrors federal legislation. Does that include the amendment that Senator Waters presented this morning?
The amendment holds harmless any New Hampshire companies, so it is not in the federal. It's just his way of protecting current New Hampshire companies. And I would just stress that the culprit, if there's ever a culprit in this, it's the manufacturers. It's not the retailers. It's not the consumers. So it's all about the manufacturers. And when you ask about, so if they're going to sell it somewhere else or they're going to manufacture it somewhere else, they have to take into consideration, just as we said the EU law changed the way the industry looked at this, that it's impossible for them to do it any other way economically at this point. But the reason, and I'll just say, the reason why this is important here and now is this bill incentivizes companies to continue that trend of replacing animal tests with better human-relevant science. It also provides industry with the regulatory alignment it seeks, that the industry seeks. As passage of this law will place New Hampshire in line with 8 states and more than 30 countries that have already banned the sale of animal testing cosmetics. So the industry is asking for this. For New Hampshire residents, it will mean that no cosmetic product on store shelves will be created using cruel and unnecessary animal testing. So I just want to make it clear that those points. Thanks.
Thank you. Senator Gannon.
It's just to follow up what I asked Senator Waters, really, a 2-part question. Do you know the percentage of manufacturers that are doing animal testing? And then the follow-up to it would be, if there are better, cheaper animal testing methods, I'm a business guy, why wouldn't I just do that anyways?
So I think I just kind of answered that. The industry is seeking these regulations just so they are aware, and they're all on the same page, and there's no international hanky-panky. So the industry's looking for this for the reasons of, I want to say, I'm trying to find the word, sameness, the ability to do business in the same vein around the world. But the other question was, sir, I'm sorry.
So just a quick follow-up, though. If the manufacturers, if it's cheaper, it's better, it's obviously going to market better, Save the Animals is going to sell anywhere. How many are still doing this, the animal testing? Is it a prevalent practice?
I don't have the answer. Okay. But if one of your constituents was concerned about that they found something on the shelf that was, then there could be a complaint made and it could be tracked down to the manufacturer. I don't know the answer to that question, but right now It's basically a consumer protection more than anything right now. Thank you.
Thank you.
Thank you.
Thank you. Appreciate it.
And Joan O'Brien? Mark, could you see if Joan O'Brien is in the hall? Wait, never mind, she doesn't want to speak. So Joan O'Brien supports it, but is not looking to speak. Anyone else here wanting to speak on Senate Bill 202? Seeing none, I'll close the hearing on Senate Bill 202.
I'd like to know if there's a problem. That's an
Yeah.
issue. No issue. Is this you? Yeah. Oh, it is you. Oh, I know what this is. Senate Commerce welcomes the Honorable Harold French to introduce Senate Bill 324. Welcome, Mr. French.
Thank you, Mr. Chair, and good morning to the entire committee. Today, I'm going to be introducing Senate Bill 324. So there were a few reasons I ran to serve in the Senate. One was to offer legislation that kept government smaller and less intrusive in our lives. Another reason was to protect our constituents from one another. This legislation that I'm offering today, Senate Bill 324, creates a dispute resolution board. It will be to assist homeowners associations, condominium associations, and homeowner cooperatives in resolving differences with their residents faster and without going to court. Some say this is an overreach of government, interfering with private contracts. I used to think so myself until I've heard a lot of testimony in this. The interpretations and resolutions of these private contracts when a dispute arises is exactly what our courts do now. This board is simply an extension of what the state already does in a more streamlined and less expensive route for the plaintiffs and defendants. Should one party or the other not agree with the decision made by this board, they have the right to continue the fight through the courts. Having sat on Commerce in both the House and the Senate, I have heard year after year from residents pleading with us to do something to address the current complaint process. This legislation is the start of an attempt to do so. This board shall hear complaints by members of these associations against their board members and shall assure the boards are following their individual associations' declarations and bylaws. It will also determine that boards are following proper voting procedures along with adhering to other actions in compliance with the association's founding instruments. There's a few people here that will be speaking on both sides of this issue. I would ask this committee to listen carefully to what they have to say and work with me on bringing this legislation forward. Thank you, Mr. Chair.
Thank you. Can I ask you a few questions, or do you want me to wait?
Go ahead,
Okay, so.
but be careful.
Thank you.
Okay.
I've probably heard more on this bill than I have on from guns to abortion. It's been a busy 2 or 3 days
Yes.
with my constituents. And their main emphasis is that, well, I'll just give you some of the problems. One was on, and then you can address them all. You have a good memory. The term limits, they're saying, like, if you're a small condo place,
Yep.
you're forcing the next person who doesn't want to serve on the board, you're kicking out the old ones who may be the experienced people who or the lawyer, or they know more about construction. So you're getting rid of people who are good.
And I agree. I saw that. I got notification of that, and that should be changed. And that's why I say this is the start of the conversation of passing this type of legislation, which we don't have. That is a good example of what we need to change in this prior to pushing it forward.
Can I ask you one more place that people seem to unanimously find intrusive, Liz? They're like solar panels doing all these. You cannot prohibit energy solutions. Then you're going to have a condo place with one big panel on top of one person's roof, sort of ugly for the rest of them, or may not be, but they're having problems with it. You're being overly intrusive into their affairs. And the fuel cells, the solar panels, which, you want a uniform-looking condo place if you have people doing different things. So they just found it was like really butting into their business.
Yeah, so once again, shoot for a trip to Mars and take a trip to the moon.
Okay. And then just one other place, item 1 on page 4, you talked about if there's a dispute, it shall always favor the property owner over the discretion of the association. So it seems like you're heading towards a certain outcome and an unbalanced scale.
I think that is, if it's a tie in the decision, it'll be
Okay.
weighted more towards the property owner than the association. I think you're going to hear some testimony from several people today that have had problems with the associations and have for years. And listen to what they have to say, and then we'll talk about
Thank you. I
the
appreciate you
concerns.
taking my questions. Just you started the bill, so I want to
Yeah,
understand
no,
where you're
thank you.
coming from. I appreciate it. Thank you.
Great.
I think it's Carly Nichols. Come on down. Welcome. Yes, ma'am.
Yeah, we'll get
Okay.
to them. We have 20 or 30 people.
Good morning. Thank you for allowing us to come and let you know what's been happening with us. I think a little part of the problem is condominiums and co-ops are very different. As stated in
Yeah.
the international, I'm sorry.
I'm sorry. When you come to testify, please state your name before you start so we can get on the record.
Okay, my name is Carly Nichols.
Go ahead.
Okay. As stated in the International Cooperative Alliance Principles, Principle 2, democratic member control. Cooperatives are democratic organizations controlled by their members who actively participate in setting their policies and making decisions. Men and women serving as elected representatives are accountable to the membership. Members own and retain control of the co-ops. Over time, boards become empowered with little accountability from apathetic community members. We all know we have them. The longer the same 5 people cycle through positions over many years, the more they feel they have control. Boards need to follow established bylaws, not pick and choose which one serves their purpose at that particular time. Rules and consequences for everyone in our community, whether a member or a board member, should be enforced equally. Boards need to encourage committees and respect their process and recommendations. When co-ops are created, basically ordinary people are expected to run multi-million-dollar businesses. For the most part, there is minimal knowledge of how to move forward in this process. Classes here and there may help, but supervision is absolutely, consistent supervision is absolutely necessary to run our business, and cooperatives are a business. In one of the other things that was asked about was our financials, and I would refer you to Exhibit B in the packet of information that we're gonna supply. Maintenance of our communities. We don't, personally, our park does not have a active maintenance department. We seem to cut trees, a lot of trees, but things are proposed to improve our public areas. Excuse me. A proposal was made, it wasn't even looked at for over almost 2 years. It was a 3-year process to help with the investment of everybody's investment into that property. It wasn't really looked at. When it was looked at, it was we asked for a certain amount of money per year, and we were told we could have what was left over from the maintenance for that year. And I think we all know that investment in your properties as homeowners means a lot. So that we don't have a very active maintenance. And there's a lot of people that have invested in homes in our community that we want to see our investment remain and grow. And that's it.
Thank you.
You're
Any
welcome.
questions from the committee? Senator Gannon.
Just similar to what I was asking Senator French earlier. A huge amount of feedback I was hearing was saying that, so you were saying you wanted turnover on the boards just to get fresh ideas, and so people don't think they're ruling the whole place earlier, correct? So on a lot of I own a condo, and I have never been to a board meeting, probably never will be. But I own other properties, and it's just not my main, and I don't have the time or energy to put into the condo board. Maybe I will when I'm older and retired on the water down in Florida, but not at this point. So you're asking, we have a group, and they're always the same people. They do everything, and they enjoy being on it, and I'm happy with them running the thing. And I don't want to turn over because they're good. At my unit, you're saying that we're going to have to try to turn over the leadership. I don't want to turn over the leadership. What would you say to me?
I would ask if you specifically know, since you don't go to board meetings, do
I read them.
specifically know how the board meetings are handled, what is being done? Is the information from that board meeting being given to everybody? That doesn't happen. And like I said, co-ops and condos are very different.
Okay.
I don't want to say the clientele is different.
Sure. Okay, thank you.
Any questions? Seeing none, thank you very much.
You're very welcome.
I'd like to call on Ned Gordon, Representative Gordon. He's out in the hallway. Could you get him, Mark?
Representative Gordon, you're up.
Thank you, Mr. Chair. Members of the committee, for the record, my name is Ned Gordon. I am a representative. I represent Grafton County District 9, which consists of 5 towns: Alexandria, Ashland, Bristol, Bridgewater, and Grafton. And I'm here in sort of a dual capacity. I also chair the Condominium Oversight Committee here in the legislature. And I come today generally in support of Senate Bill 324. And I'll express it this way. This bill provides, first of all, just in terms of background, this is a bill very similar to a bill which was 2 years ago passed by the House, sent to the Senate, and then not acted upon in the Senate because of COVID. Last year, there was a similar bill having to do only with condominiums and creating a dispute board for condominiums, which went to the House Commerce Committee, and with a divided vote was unsuccessful and did not come out of the House. However, the Condominium Committee sponsored that bill, and the condominium committee has heard repeatedly from unit owners that the current process for addressing matters with regard to condominiums is difficult for them to go forward with. And I have to say, being a former judge as well, that right now our court system needs repair. I probably don't need to tell you that if you've heard what's been going on, but frankly, they're not even holding trials in the whole month of January in our Superior Court, which is where these matters ordinarily are heard. They are backed up extraordinarily. They have to give priority to the cases that have the highest priority. Criminal cases have the highest priority. These type of cases don't have priority. For a homeowner to go to the Superior Court is very difficult. And it's very difficult because I can tell you appearing in the Superior Court is intimidating. You ordinarily have to hire an attorney in order to do that, which is an expense which many homeowners can't afford. And so some type of alternative dispute resolution board is something which we think is appropriate. There is a dispute resolution board for manufactured housing, which was put into effect 20 years ago, which has operated very successfully over time. And the last bill that was proposed had to deal only with condominiums, but I have to say that our committee has heard over and over and over again that there is also a need for homeowners associations, and there is very little legislation with regard to homeowners associations, and a need to resolve disputes there as well. Long and the short, the committee supports this. It supports it totally in concept. It recognizes that there may be things that need to be addressed in the bill itself with regard to the relationship between homeowners associations and unit owners, and between condominium boards and unit owners. And so I think in terms of the bill itself, there are things that we address, and I'm sure you're going to hear about those things today, and you're going to have the opportunity to address them here. But as far as the condominium oversight board is concerned, we're fully supportive of having an oversight, a alternative dispute resolution board, because we think that's in the best interest of the citizens of the state. That's my testimony.
Thank you. Questions? Senator Gannon.
So, Judge, you heard my questions earlier.
I didn't.
Oh,
So-
you were out in the hall, I'm
Yep.
sorry. There are a lot of parts where it's just, my constituents have found it to be very intrusive. Term limits and so people serving on the board, who serves. I'm in a condo, I don't want to be, I want to place Szion, I don't want to be on that board. There are people who are interested, who have the skills and desire to be. I'm happy if they serve on it for 20 years. I get my notice, I read what's happening, and that's good enough for me. And then this bill also said, like, on energy issues, if you you could put a solar panel up, you could do a lot of things as long as they were alternative energy solutions. Then you're telling the condo who may not want a solar panel on top of their roof what they're doing, and they just found this very intrusive on their personal property rights.
And I get that, and I think as far as the oversight board is concerned, what we're interested in having is making sure that boards in particular comply with the articles that create the board, with the bylaws. Okay, and that is really what our interest is in doing.
Thank you.
Others? Seeing none, thank you very much.
Thank you, Mr. Chair, and members of the committee.
Lou Gargiolo, he's out in the hall.
What's the onion for? You're making a soup?
Assisting some of these residents.
Yeah, someone gave me an apple. You gave him
Good morning, Senators. My name is Lou Gargiulo, and I reside in Hampton Falls, New Hampshire, and I'm the CEO and founder of Great North Property Management, which is based in Exeter, New Hampshire. My firm is responsible for the management of more than 25,000 condominium and homeowners association units that house approximately 75,000 people. I am here today in strong objection to Senate Bill 324. In my opinion, this bill is a solution in search of a problem that does not exist to any great degree that warrants creating another government board. The language in the bill is convoluted, and its contents, for the most part, substitutes the wisdom of a board who are vested in the interests of the property to an appointed board of outsiders that don't understand the dynamics or needs of a particular property. It also attempts to legislate actions of a homeowners association in contravention to the deeds, declaration, and bylaws, and will make an association almost impossible to manage. It will open the door to higher legal fees and more litigation. I would like to point out some specifics in Roman numerals on page 4 and 5, Roman numerals 1 through 7. And there's a whole load of them. But some that really stand out. Number 6, okay? Association shall have a minimum of 3 voting board members. Each will serve 2 terms. No homeowners association board member shall serve subsequent terms unless and until the board and other members of homeowners associations have served on the board. Homeowners association board members shall live on site 75%. That alone, okay, makes virtually an impossible situation. First, it's almost impossible to get people to serve on boards. You generally have to beg people, and those who serve on boards, for the most part, are dedicated professionals who are trying to do the best for their particular community. To believe that you're going to be able to get people every year, every 2 years, to serve on boards, and you're going to somehow force them to do it, on its face is ludicrous. Second, the board members shall live at the community 75% of the time. What sense does that? Does a person who doesn't live there 75% of the time have less of an interest in the property? Thirdly, no consideration for investment owners. There are owners who invest in property, who own it, and still have a significant interest in the property. But that has been totally discounted in this particular piece of legislation. Next one that comes to light, and it was spoken about before, the whole issue of alternative energy sources. I, for one, am not opposed to alternative energy sources, but I want you to consider this. In a community association, in many cases, the roofs are owned by the association, the land is owned by the association, and each of the individual owners have an equitable interest. How right is it for a person on the first floor of a condo unit to have somebody install solar panels on the second floor above them? And what happens if there are leaks? The roof, in most cases, not always, but in most cases, is owned by the association. Again, this is a critical issue. If you look at the language in this bill also, it speaks to about any reasonable clean energy alternatives. What does that mean? There are, now and in perpetuity, if this legislation passes, it could be solar panels, it could be windmills, it could be a whole array of different purposes. So those are 2 that truly stand out. Then if you look on 1 and 2 in terms of favoring, when an association brings forward a claim against a unit owner, it's generally based in reasonable fact. I'm not suggesting that there are not problems in some cases, but those problems are generally litigated, and if they become a problem. But when you consider that the association has to go in a board like this and prove its case to a board, and then most likely the person who's potentially aggrieved then appeals it, they can go to the Superior Court. Do you think for one moment that an association or a management company is going to go before a board like this without counsel? which is going to require them to have counsel for this board. It's going to require them, if it's appealed, to have counsel for the Superior Court hearing. So all of those things is going to create additional consequences. And I particularly love a provision in the fiscal note of this particular bill. And if you look at the fiscal note, it says, the Department of Justice states there is no indeterminable fiscal impact on state expenditures. The department is unsure how many complaints will be filed and the amount of counsel needed to assist the board in judicial filings. With that said, the bill will accomplish two things. It will significantly impact the government and governance and community associations. It will cost the taxpayers of the great state of New Hampshire indeterminable amounts of monies to provide a solution to a problem that there are a huge number of people outside who will tell you, in their opinion, doesn't exist. I ask you to look to inexpedient to legislate. This bill is not ready for prime time. The language in it, if you decide that you want to have a resolution board, the bill needs to be carefully crafted and has to be very specific. This bill is also bringing forth legislation for homeowners associations, condominium associations, co-ops, and they're all creatures of statute. They should be treated differently. And to lump them into one board makes it hugely problematic. So with that said, I'm open to any questions any of you might want to ask me.
Great, thank you. Overall, I take it you like the bill.
Senator, I think it's fabulous.
Thank
And
you.
I think that a lot of people put work into it, but I honestly think that it wasn't thought through with the user, the people who have to be impacted by it. And I do think, and I heard Judge Gordon's testimony, and certainly there may be a place for some sort of board, but this particular legislation is not the kind of board that is going to function well in New Hampshire. It's going to create additional taxation because there are going to be costs, and nobody knows what the costs are going to be. So I think it needs to be thought out.
Yep. So the underlying idea of having a dispute resolution board isn't entirely objectionable. It's just what that board can do and some of the other criteria within the bill that you didn't like.
I think instead of creating another board, okay, it might be more preferable to include language in the condominium statute 356B that says something to the effect that an association should have a dispute resolution process that's mandated by statute, as opposed to having an outside board with an indeterminable amount of cost, with outside people, in many cases, who don't understand the landscape of a condominium association.
Great, thank you. Any other questions? Senator Bradley.
Good morning. So I think you've spoken primarily to condominium associations and homeowner associations. Do you want to comment at all on co-ops, because they're quite different?
They are different, and that isn't my area of expertise. But in condominium associations and homeowners associations, I think that the issue is flawed, and I'm not going to speak to something that I'm not familiar with. I've been involved with homeowners associations and condominium associations in New Hampshire for over 30 years, and I understand the landscape. I have a large portfolio of my own that I own, and I recognize the idiosyncrasies of operating those entities, and I recognize the hard work that board members put in, and to strip them of their responsibilities, and essentially this will create some level of bringing forth what an association board is elected to do and giving it to bureaucrats in Concord. Not a good look.
Further questions? Thank you. That's
Thank
why
you.
we have these conversations.
Thank you, sir, and have a wonderful day.
You too. So we have, I don't know, 150 people looking to speak on this. So please keep your remarks brief, and we'll push right through. Sylvia Dion. Come up, Sylvia. Don't run.
My name is Sylvia Szion. I'm from the Lakes Region Mobile Home Park in Guilford. And what I wanted to say was the members of the board should not be on, as we have one particular person that's been on the board since we started in 2009. And only 1 year did we get him off the board. And he didn't like it at all. And it ended up he got a petition to get rid of us, which was an all-female board by the end. And he doesn't like women, particularly me. And
I can see why.
I just think that he should not be allowed. He should not be allowed to be on the board that long. Now, our last annual meeting, I argued with him, and Rock stood up for him and said he has every right to be on it. But he's been on it for more than 10 years. And he just thinks he owns the place. And personally, I do have a personal thing with him. He came to our meeting June 20th, 2019, female board, and he exposed himself to us. And he should have been off the board. He shouldn't be allowed on the board again, and he was. And since then, I have had PSD because of my past. And I think that he's just overpowering us. He, like I said, he thinks he owns it, owns the park, and no matter what, he doesn't follow any rules. He just goes ahead and does what he wants. And that's just my doing. I mean, I'm just saying this. Thank you, French.
Thank you for coming in. Any questions from the members? Seeing none, thank you for your time. Representative Alme, come on down.
That's more my size. I'm Representative Susan Alme from the City of Lebanon, Grafton 13 in the House. And I've been, I started the Condominium and Homeowner Association Study Committee in 2009. And the next term it got turned upside down, and then we got together again and have always, except for that one term, been bipartisan in our work. That is, we've usually been 2 and 2. We have suffered badly from quorum problems because we didn't notice that the Senate had removed one of its 2 members, which was quite understandable that you did that. And so we have to have 3 people each time we meet, and we only have 4 to deal with. So because of that, and because it took a long time for Senator French to add the Homeowners Association part to the condominium bill that we've been trying to get passed for the last 4 terms, we did not have time to read through the text of this bill properly in the only meeting that we could still have last year before the bill had to be introduced. Several of us signed on to it, anyway, because this is such an important issue for both the condominiums and the homeowner associations. We had not been dealing with the homeowner associations except to take horror stories from various members of homeowner associations that contacted different ones of us because they are very lightly represented in our law. And it made it a more difficult issue that we wanted to put into this bill after we had the condominiums settled with something that they could use, which I'm sure Senator Gordon has told you about. We could use to allow failing condominiums or homeowner associations to turn themselves around before they destructed. And we have a lot of homeowner associations and condominiums that work very well. I run a homeowners association of 22 units. It works fairly well, except for the fact that I and a person older than I are two of the four members of the board and have been trying to get out of the positions for quite a long time now. That's one of the problems in a part of this bill that we would have considered if we'd been able to work as the committee on it before the bill came in, because it requires that every single member of a homeowner association serve on the board in a kind of rotation. And I think almost all or all homeowner associations must have at least a few members. Half of mine adamantly refuse to have anything to do with serving. We've got people that are very aged, taking care of aged relatives, spouses. We have people that are severely disabled and are willing to come to meetings, but they won't come to a board meeting. And we have a large number of people who work very full-time at the hospital and don't have time to give for that. So the difficulty of all of this, and the reason that we need a dispute board, is that we can't make law for all of these different situations that different homeowner associations and different condominiums find themselves in. What works for a large one won't work for a small one. What works for one that where the board sees as its prime goal to serve the people that live there doesn't work when you've got a small group of people that formed the board and that are using the other people in the homeowners association to pay for the general expenses, but not giving them equal rights and not giving them information about what's going on in the place. And if any of them start asking too hard, do things like plow up their lawn with a snowplow and never fix it, or build a new unit right in front of them so that they don't have a view anymore, or throw red paint at their apartment door while they're at work, or disable the elevator because the person is disabled and lives on the third floor. These are just some of the many things that we've heard over the years that go on when an ordinary member tries to get involved in governance. And the dispute board is to try to have as neutral a board as possible, made up from all the interests, that will listen to the complaints. And I'm sure Senator Gordon, who had something to do with the Manufactured Housing Board that was created in the 70s, no, late 80s, I think. He probably, he must have described this to you, but part of the importance of it is to listen to the cases and decide on them, wait and see if anybody appeals it, and then take it to put it into the case law of the state of New Hampshire. And the case law is much more usable for these very varied situations than us trying to set up a law that tells every association or of whatever kind how it has to operate, because some of them can't. I live down the street a little from a old farmhouse that is an 8-unit condominium. I'm not sure it ever incorporated. A lot of them didn't incorporate. But they were running things without bylaws until they started to get in trouble about agreeing on who was doing what. And the old guy who was running things there came to me and said, "You have bylaws, can we see them?" So there's a lot of variation between, and we need this bill, but we also, if we could, need the ability to go back as the committee and talk about the various things that have to be changed in it. I haven't been able to hear what people are complaining about, but I'm sure they're complaining
It's a little.
about some of the things that came to me, because I've been working on this a long time, so I've been hearing from very varied groups with very varied problems, and some of them are legitimate and ought to be solved so that the association will continue, and some of them aren't, and that's what the board would be for.
Great, thank you, Representative. Any questions? Seeing none, thank you for your time. We have Rick Sweat. Good morning.
Good morning, how are you?
Good.
Well, good morning, Senators. Thank you for the opportunity to speak at this public hearing on SB 324FM. My name is Dick Sweat. I'm a resident of the Vineyards at Stratham Condominium Association in Stratham. I think some of your speakers have noted that there is a difference between condominiums, homeowners associations, and cooperatives. I am speaking as a condominium member. I was elected to the association's board in October 2017. I have served as president of the board since September 2019. I'm a retired banker and I have no legal training. However, I believe my experience in managing the condominium association affairs brings me to the public hearing to discuss this particular bill. During my years of service on the board and as president of this association, all resident disputes have been settled within the framework of the association's condominium declaration, bylaws, and rules, and they were recorded in 2001. So they've been on the record for a number of years, more than 2 decades. The Vineyard Board does not believe there is a need to establish a dispute resolution board for condominiums when the existing regulations in RSA 356B are sufficient, combined with our declaration, bylaws, and rules. The Vineyards Board does not believe the following statement on page 4 of the bill review to be fair and balanced. Quote, in the event of a dispute between a homeowner and the association, resolution of issues shall favor the property owner. The word shall means an obligation. I don't see there should be any obligation to favor one party over the other. The Vineyards Board does not agree with the following statement on page 3 of the Bill Review Board. I quote, "The board shall not be bound by common law or statutory rules of evidence, but may admit all testimony having a reasonable probative value. Substituting the application of common law and rules of evidence with testimony having a reasonable probative value makes board decisions subjective and inconsistent." The Vineyard Board believes that RSA 356B35, titled Contents of Bylaws, was to declare that condominium bylaws were to be written, and I quote, "providing for the self-government of the condominium association of all unit owners." The Vineyard Board believes that the addition of the new subdivisions RSA 356B71 through RSA 356B79 is counter to the concept of self-government by the unit owners. The Vineyard's bylaws contain practices that provide for good condominium governance. We have governing transparency. We have 10 days prior notice for board meetings. We have 20 days prior notice for annual meetings. The board meetings require a resident open forum, so residents can come before the board and express any grievances they may have. And we require the timely dissemination of board and annual meeting minutes to the residents. We have term limits for directors. You're limited to 2 consecutive terms, and directors and officers are not compensated. The purchaser of any unit signs an acknowledgement that they have received and reviewed the condominium declaration and bylaws. Article 7 of our bylaws deals with compliance. The proposed RSA 356B74 provides for final relief by appeal to the New Hampshire Superior Court. This is the same court that would decide a case without the added burdens and expense required by appearing before the Dispute Resolution Board. The Vineyards Board believes that the proposed Dispute Resolution Board will prolong the resolution of disputes, add an unnecessary layer of legal processes that may be resolved at the same Superior Court, and burdens all parties with unnecessary attorney's fees and court costs. The Vineyard Board recommends deleting all the subdivisions in SB 324FN that pertains to RSA 356B. Homeowners associations and cooperatives should have statutes enacted like RSA 356B to establish documents that have acceptable governing standards to settle issues that arise between owners and their respective associations. If owners living in condominiums, homeowners associations, and cooperatives are not happy with the elected board's governance, the remedy is to elect new board members. The solution is not to establish a dispute resolution board that remedies the systems but does not eliminate the governance problem. It is recommended that the committee continue its work on looking into these disputes. It is requested that this presentation be made of your public record, and the Vineyards of Stratham Condominium Association thank the committee for the opportunity to be heard at this public hearing. Thank you very much.
Thank you. Any questions? Seeing none, thank you very, thank you very much
You're
for your
very welcome.
testimony.
Thank you for your time.
Now, the next one is, I can't make it out. It's either Diver Jerry, Olivia Jerry. Gary, there we go.
Thank you. My name is Olivia Geary. I live in the Lakes Region Mobile Home Park. I've lived there for more than 30 years, so I was there way before we went co-op. And I just want to tell you that our park, when we moved in, was the perfect park. It was well kept. It was all maintenance, was all done. We had an operation manager that was doing all the work, and it was perfect. Somebody in the park wanted to do a co-op, so they got it together and they voted on a co-op. We didn't want it, but it went through. And now our park, you can walk through our park, it's horrible. The places are not kept, and the board does nothing. I've written notes, I've put pictures in, nothing. They don't even get back to you. And It's all run by this one person, and he's been running it, and he's doing a lousy job. It's only for himself. And he's doing pretty good, but we're not. We have junk cars in our yards. We have people parking on the grass when they have a two-car driveway, which is what's supposed to be. The rule is no parking on the grass. And we have people just going up and down, coming in. There's no rules. They're not enforced, and it hasn't been for quite a while. And people put anything they want in their yards, and it looks horrible. And it's bringing down our park, which was the best park in Guilford at the time we moved in. And I just wanted to say that the board is not good, and we need to have something better than that board. We need a managing company to come in and take over and run our park for us. And I guess that's all I had to say. Thank you.
Thank you. Questions? Senator Gannon.
You and your lovely friend, why don't you guys run for the board?
Pardon me?
Change things. Why don't you run for the board?
Well, because if one of us or anyone here, and some of us have been on the board, that one person, every time somebody wants to do something good, he shoots it down. So he's the one that tells everybody what's going on. It's the same person. And he's been on the board since the co-op started, actually. And we can't get him off.
Thank you.
Thank you. Dean Lennon. What's that? Yeah.
Glad I live on 10 acres.
I'm going to move into that Guilford Park, take it over.
That's right. Did vote for it.
Yeah.
Good morning, Senators.
Morning.
Good morning. I should just jump right into it here?
Sure.
Thank
Go
you
right
very
ahead.
much. This bill is...
Could you just introduce yourself prior to...
Certainly. My name is Dean Lennon. I'm an attorney with the law firm Marcus Arico, Emmer & Brooks. We're located in both Massachusetts and New Hampshire. And I'm also a member of the Community Association Institute Legislative Action Committee for the state of New Hampshire.
Thank you.
Thank you. As I see it, this bill is medicine for a problem, for a sickness that doesn't exist. There is no epidemic of renegade boards run amok in the state of New Hampshire. When someone calls their senator or congressman about a problem, it's because something egregiously bad has happened. That's the 1%. People don't call their senators, they don't call their congresswoman when the board does the right thing, when the board resolves an issue without a blow-up, without going to court. That's what happens 99% of the time. You're hearing from some people today who have very particularized problems for their particular condominium, but this is not a statewide issue. As this bill relates to HOAs in particular, but also to condo associations, I consider it to be an affront to the people who devote their time and effort to being volunteer board members. They are spending hours upon hours upon hours every week running their associations. For no money, for no credit, they only hear the complaints. And what this bill is seeking to do is replacing their judgment and wisdom with an unelected dispute resolution board comprised of 6 members who may have no experience with condominiums whatsoever, or, when it comes to HOAs, the will of an individual person. On its face, this bill states that, I just want to quote so I don't get it wrong, in event of a dispute between a homeowner and the association, resolution of issues shall favor the property owner, and the association shall not have sole discretion over any issue. This is nonsense. HOAs and condos have boards, much like the state of New Hampshire has a Congress. Congress makes the laws, boards make the laws, they enforce the rules and regulations. That's their role. This bill on its face is biased towards the owner and allows and flips the administration of condos on its head by saying the board doesn't have sole discretion over it. They do. That's how this works. And if you don't like your board, you have to vote them out. And no one board member controls a board. It's a majority vote. So if you have one bad guy on there, presumably you have 2, 3, or 4 others who can override the will of the one bad guy. As far as term limits go, I notice there's no bill before this committee about term limits for senators or for congresspeople. You're seeking to limit owners to serving 2 years, and then they can't serve again until 100% of people have served. That's never going to happen. First of all, units get sold all the time, so there's always going to be someone new. Therefore, you'll never be at 100%. But even if you could get to 100%, people don't run. You've already heard that. Lou Gargiulo made that point very clear. We have to beg people to run. Management companies beg people. Please do this. If you don't do this, you'll have no one to make decisions. So the idea that you're going to have this turnover of fresh faces ready to get after it, make a change, make a difference, it is simply not going to happen. And finally, as far as the provisions on solar and other alternative energy, forcing homeowners to accept or forcing associations to accept these irrespective of what's in their docs is problematic on many, many reasons, because there could be valid reasons for rejecting solar panels on a roof. If you imagine a garden-style building, there's only so much real estate up there. 1 or 2 people might have solar panels. What happens to the rest? Do they put them on the lawn? Maybe the roof needs to be replaced and it can't go on this year. There are a million problems. This bill was very poorly thought out, and frankly, it needs to be defeated in this committee, and I'd urge you to do that. Thank you very much.
Thank you. Questions from the committee? Seeing none, thank you for
Thank
your
you.
time. Scott Wolf. Wolf.
Good morning. How are you today? My name is Scott Wolf, and I am involved with the CAI New Hampshire Legislative Action Committee, but I'm not here in that regard. I am here as the owner of a property management business that handles approximately 15,000 condominiums and HOAs. I've been in business for approximately 30 years. And I have been heavily involved with Community Association Institute and the industry during that time frame. Past president and in the sort is involvement with CAI. I'm here talking for my management history background, and also I'm a homeowner in an association in New Hampshire. So from my perspective, the first thing I would say is I am opposed to how this document is written. I would sell my home if, in fact, this went through, for many, many reasons that a lot of my colleagues have spoken to, and I know there's a lot of people behind me, so I want to be brief and just kind of touch upon some key points that haven't been mentioned. And I think the biggest is you are dealing, actually, Dean just mentioned 1%. And to my belief, that is what we in the industry do consider to be a bit of a problematic. Most things work well. There is 1% of every association where there are going to be misunderstandings, confusion that need to be resolved. The majority of these are settled with the condominium documents and the governing documents for the association. There's very few times, in my experience in over 30 years, that this goes to legal and attorneys and all that. The boards work very hard as volunteers. They are not compensated for what they do, and the documents allow for owners that are upset to vote them out, to get a new board member. The biggest issue we have is complacency. You can't find board members. You don't find people that want to run for the board and be involved. So the document being presented, having everybody be a board member, won't happen. You know, we are looking at actually changing, amending the condominium documents for many of our associations to reduce the quorum necessary to actually have an annual meeting or vote. And a lot of associations have moved that from over 50%, some cases 75%, down to 25%, because they want the people that want to be involved, that want to be doing it, to be able to. So there is, with this, I don't know where you're going to find the people. A lot of people, educating people before they buy a condo or an HOA would be wonderful, because I think most don't realize what they're getting into when they do it. We've had, I can say in the last month, I've had 4 annual meetings, and we haven't had a quorum at a single one. We've had elections, and yes, we've had board members that are on for 15, 20 years. I do think there should be turnover. I don't deny that, but at least they're volunteering and they're actually doing it, and people are not stepping up. People are not wanting to volunteer to do it. With my home, I don't want anything to do with the board. They send me documents, I sign them, I send them back, they send me my fee, I pay them. It's my choice, because I actually think I know too much to be wanting to be on my board. But I think that that is one thing that truly has not been displayed from anybody prior to me, is it's getting people involved. And frankly, it's not as big of an issue as this bill makes it appear. I have to say that the majority, 99% of our associations that we manage, the people are good. The boards care, and the boards want to resolve issues. A lot of the complaints we get are violations of the condominium documents or the HOA documents, and the buyer or owner just doesn't agree with the outcome. There is a lack of knowledge when people buy into these communities. I think it should be required that they read all the documents, that they understand what they're buying into. But finding anybody that's, and additionally, having all the turnover, having consistency on the board with staggered terms is a much better thing. If you have a 3-member board and you have 2 years, have them expire 1 per year. Just different things. I understand the reasoning for the proposal of the bill. However, I really think it's just going to create more problems and more cost for the state of New Hampshire, and frankly, the people that are going to win are the lawyers, because no board member or management company is going to appear in front of that dispute resolution board without an attorney. So they're gonna win. I'm not an attorney, just saying. As far as again, with the solar and all the energy efficiencies, I can say that the majority of our associations are already looking into what can we do, what do we need, energy charging stations for cars. The world is evolving, so they are looking at these things. Even without it being legislated, they're already being aware. But again, as it was said previously, there's no one size fits all. You know, there are so many different styles and designs of condominiums and HOAs. I'm not speaking to co-ops because it's not an area that we have great expertise in, but they're all different. And if I live on the 2nd floor and you live on the 1st floor and want to put the panels above my roof, how's that going to work? What happens when you run out of green space? It's finding that balance. Overall, I truly believe that the documents and how associations are running is quite well. Could it be improved upon? Absolutely. But I do not find that this bill is going to address that. I think it's going to create more issues. Any questions?
Thank you. Questions? Seeing none, thank you, Mr. Wolf.
Thank you, everybody, very much. Have a good day.
You too. Lee Greenwood? A lot of them aren't speaking.
Morning.
Good morning. Please state your name and
Good morning. My name is Lee Greenwood. I am here representing Associa, and we are here strongly opposing this bill, 324. Excuse me. Associa is the largest community association management company in the country. We have been in this business for over 4 decades. We have a physical presence in 38 states across the country, and in New Hampshire itself. I just want to get these facts right. We employ nearly 150 people. We manage over 25,000 units. We have managed 350 associations, over 350 associations across the state, and we have been working throughout New Hampshire for, like I said, for almost 4 decades now. like I said, we oppose 324. In our opinion, this is a bill that is a solution in search of a problem, to be honest, as you've heard from, from many of our colleagues, and you'll hear more. I think that's why so many people are here today, because this bill will fundamentally alter and disrupt the housing model that nearly 265,000 residents of New Hampshire live in a condo, an HOA, or a co-op. And I just want to cite some of the statistics, from the Community Associations Institute. They've done a lot of polling on this throughout New Hampshire, throughout the country. And what they consistently find, and what they have found in New Hampshire, is that almost 90% of community association residents rate their experience in one of these associations as either positive or neutral. In other words, 90% of people are satisfied with the model that they have are living in, and which is why so many people are buying into these types of into this housing model. In fact, like I said, it's nearly 20% of the state's residents who live in this model right now, and that those numbers are growing exponentially. I can't speak to when it will be, but at some point in the future, there are projections that the majority of folks throughout the country will be living in some sort of community association. And nearly 3/4 of those people who were polled have found that, or have said that they oppose any sort of state regulation, more state regulation of their housing model than what exists right now. So again, this is an industry and a marketplace that is vibrant, that is successful, and where the consumers, the people that legislation like 324 is meant to protect, they are satisfied with what is happening. They are happy in the places where they live. Now, are there outliers? Of course, that happens everywhere. But the problem that we see with 324 is it is a one-size-fit-all approach to a community that, like I said, represents 20% of the state's population. People choose this housing model for a variety of reasons, but one of them is they like local control. They move into a community because they can directly elect their board of directors. Their board of directors can then help manage their community, and they can live in a community where they have rules that fit the needs of those residents. This bill would remove that autonomy and would remove their freedom to live in a model that they have chosen and that they are satisfied with. I won't go into too many of the specifics of the bill. I know a lot of folks are speaking, and I want to be respectful of your time. But just generally speaking, the Dispute Resolution Board, we think, is completely one-sided and just unfair and unjust. And ironically, I think, in my opinion, this board will actually raise housing costs for folks when it's trying to save money. I mean, there is a language in there that calls for appeals, where either party can appeal to the Superior Court. Well, given the one-sided nature of the language in the bill and the board that would be developed if this becomes law, everyone's going to appeal this. So what those appeals are going to cost money, and those money will, of course, be passed on to the association and then to the homeowners. That's bad for everybody. On the HOA provisions, again, what this bill is trying to do is basically, we view it, I'm not prone to hyperbolic language, I promise, but I have 2 small children at home, so I don't get the luxury of being extreme or hyperbolic. But I believe that this bill is a fundamental frontal assault on the housing model of HOAs and condominiums and co-ops. And again, this is a model that folks are happy with, they are satisfied with. And if this bill becomes law, I just want to be clear, this makes New Hampshire an outlier throughout the country. There are no states in our region who have any provision like this in their law. There are, I believe it's only 5 or 6 states throughout the country that have any type of process like this, and none of the states have anything that would be as one-sided as the approach that is modeled in this bill. For all those reasons, obviously, we oppose this bill. We hope that you will continue to work with our industry to help improve things for consumers, for the state's residents. But I just want to know one more thing, sorry, before I leave, that many of the folks who work professionally in this industry are here today, voicing their opposition to this bill. To my knowledge, not a single person from our industry was contacted to actually help develop any language in this bill, which to me is problematic. If you're going to have a bill that fundamentally alters an entire industry, I think it's good to have the voices of all stakeholders involved in that, and that was not present here. So For all those reasons, committee, we certainly oppose this bill and hope that we can work together to find solutions to whatever problems exist out there for you and your constituents. Thank you very much.
Thank
Have a
you.
great day.
Questions? Seeing none, thank you for your time.
Thank you, sir.
Michael Feniger?
Good morning.
Good morning.
Seems to be a long morning on this particular issue.
Yeah, I thought there might be. We've had a lot of testimony today in opposition.
Right.
So if you can keep your remarks to the minimum, if you're, when you're, yeah, thank you.
No, I appreciate that. Just for the record, my name is Michael Feniger. I'm an attorney in New Hampshire. I'm the chairman of the condominium section of the New Hampshire Bar Association. My firm represents condominium associations, but we also represent individual unit owners, not just in a condominium setting, but in settings that involve subdivisions and in settings that involve what is being termed homeowners associations. I just want to point out, there is no definition of a homeowners association at this point in time in New Hampshire. And people interchangeably use an HOA with a condo association, and they use that phraseology. But a couple of years ago, there was a bill that was drafted, which was a homeowners association bill. And that bill, which was about 41 pages long and doesn't seem to have gotten anywhere, would have helped to define what it is that we're trying to control here today in this legislation, because that's what this really is. So my point would be that if the legislature sees fit to create some form of control over homeowners associations, which in my personal opinion is unnecessary, then the first step is to draft a homeowners association statute so that we can define, much like the Condominium Act, what a homeowners association is and how the control is placed in this homeowners association. I will point out also that in the present bill, especially with regard to the addition to RSA 477. RSA 477 is a conveyancing statute. It has nothing to do with the control of property after that property is sold. And what this statute that's being proposed here today does essentially circumvents the legislature's obligation to actually create a statute and define what a homeowners association is. As it stands today, a homeowners association is nothing more than a subdivision that has some common interest. Typically what we see is a common well or a common septic or maybe a beach or maybe a clubhouse. Oftentimes there could be roads that haven't been taken over by a municipality, but it has very limited control as it stands today over the individual unit owners, other than to collect assessments to defray the cost of those common area expenses. It's not really like a condominium association where the only thing that the unit owner typically owns is the paint and paper on the inside of the unit, and the association is responsible for everything else. Right now, homeowners associations are controlled by RSA 292 because they have to be organized in some fashion, and 292 is the voluntary corporation statute. That particular statute brings with it articles of an agreement, and it brings with it the requirement of bylaws, and that statute tells what has to be in the bylaws. And as a result of that, we have adequate controls. The court system works quite well in terms of addressing the needs of any unit owner who may have a complaint. I get calls from lot owners, unit owners, all the time. And I will tell you that almost 99% of the time, these people have not read their condominium or homeowners association documents. They're relying on their sense of fairness and what they expect should be happening, not the contract that is what they purchased. They don't read the documents before they buy it. They don't hire lawyers who are familiar with condominium or homeowners associations to review them and report to them. And they go into these things blindly. There comes a point where the state cannot legislate protection over people who won't take any responsibility for themselves. And I think we're at that point. So as my last thought is this: if you're going to create a statute or an act that's going to govern homeowners associations, first we need to figure out what wrong has to be corrected, what abuses have to be stopped, if any even exist. and it shouldn't be placed in a statute that deals with conveyances of real estate and mortgages, so that it's kind of like hiding the ball, that people don't really even know where to look. It should be somewhere where people who have an interest in that type of lifestyle can find it, and it sets out what the guidelines are supposed to be. Thank you very much. I appreciate your time.
Thank you. Any questions? Seeing none, thank
I
you
didn't
for your
think you would
time.
have any questions.
I appreciate it.
Thanks.
Eric Shaughnessy. I think I threw a big rock into a little pond.
Yep.
Yeah.
Good morning.
Good morning. Would you introduce yourself?
Of course. My name is Eric Shaughnessy. I'm with the law firm Marioni, Shaughnessy and Udy, and we represent condo associations and HOAs throughout Massachusetts and New Hampshire. I'm here in opposition to this bill. You've heard from a number of people that I work with in the industry already. I will attempt to keep this brief, as you've heard a lot of information I might already be speaking about. In addition, I just want to simply say that I support what you've heard from them and what you will hear from other people. And I don't need to list their names. I think you know who they are. So the first thing I want to address is what this bill seeks to do, which is it seeks to create a fundamental change, and a drastic change to the governance of community associations. And I find that problematic, right? What's happening is you're substituting the decision-making of a community elected persons for that of an administrative appointed board. So you're taking what was created intentionally and set up for individuals to elect from their own group, people to govern themselves, and saying we're going to shift that decision-making to somebody else that is not related to the community. And I think it defeats the intent and purpose of these community associations. And so another aspect of this bill strips entirely the authority of the community elected members, and that has to deal with the alternative energy solutions, right, where it says you have to, automatically, it's without discretion, approve those alternative energies. There's no vote of the community. There's no seeking input. It's if somebody wants to do it, this bill says it must be done. And I find that very problematic. Currently, with any community association, you can do these things. It may require an amendment to your governing documents. It may require a vote of the community to do it, but it's not prohibited. It is absolutely allowed, but it's based upon how the community feels about it and whether the community wants these items. And I think that's the fundamental issue that should remain in place, is that the communities can regulate themselves, have been effectively regulating themselves, and have the provisions already at their disposal to continue to do so and address a lot of these issues. So that is the kind of big picture issues that I see with this bill and why I'm in opposition to it. I don't know if there's any questions. I know you've heard a lot of this already, so I'll
A little bit.
yes.
Thanks. Questions? Senator Gannon, of
Quick
course.
comment. We do go to law school. You're so good at issue, rule, analysis, conclusion. Boom, 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 boom. You were great.
I went to Suffolk and Boston.
Very good. Thank you.
Thank you.
Thank you. Gary Daddario.
I support Gary State.
Good morning. Would you state your name for the record and?
Hi,
Hi.
good morning. Gary Daddario. I am an attorney, a partner at Marcus Rico, Emmer and Brooks. You heard from Attorney Feniger a few moments ago. He mentioned the condo section of the New Hampshire Bar. I'm one of the officers of that section along with Mr. Feniger. But I'm here this morning in my capacity as the chair of the New Hampshire Legislative Action Committee from Community Associations Institute. You heard from Lee Greenwood a few moments ago from Associa. He, like CAI, works on a national level. So I'm going to try to not repeat points that you're hearing today. I know that you're hearing a lot from a lot of people. I'll try to keep it brief, but there is a lot to address, if I'm being honest. First off, I would suggest that New Hampshire try to be careful about solving problems that don't exist. I know that you've heard this before, but I'd like to try to put some perspective on the issue. Mr. Greenwood may have mentioned this fact, but according to the records at Community Association Institute, their data indicates that 265,000 Granite Staters live in associations. So I don't know how many folks are contacting the New Hampshire legislature to report problems about their communities, but I suspect that as compared to the pool of 265,000 unit owners in New Hampshire, that we're talking about an almost immeasurably small percentage of the homeowner association and condominium community as a whole. And so therefore, I think that one problem with this bill is it's global, it's concrete, and it addresses the problem on a systematic level when I think you don't actually have a systematic problem. I think another issue is the creation of additional government. We're talking about in this bill the creation of a state board that at present doesn't exist. I don't want to be too cliche about this, but you know, New Hampshire has been proud to be the live free or die state for a lot of years. I moved here myself as an adult, and I'm a resident of the state now, in large part because of that attitude and my desire to live in a state that operated in that fashion. I think this bill is a real step away from that because we're now looking for the state government to not only expand, but to get into an area that it doesn't need to be into. Partly because the problem's not big enough, partly because other avenues such as court already exist, and partly because at the heart of the matter, condominiums and HOAs are supposed to be governed by their own documents. They're created by those documents. They wouldn't even exist but for their own governing documents. And the idea when those documents are drafted is that that is going to be the statements and provisions, the terms and conditions by which everybody at that association abides. There are homeowners and unit owners who buy into associations for what I call the right reason, meaning that they take a look at those documents, they take a look at that scheme of ownership, including even the rules and the restrictions, and they say to themselves, yes, that's the type of community in which I want to live. And the problem when the state overrides those documents is that you're taking away the community's ability to be the community that it was designed to be, and you're taking away for what is really the vast majority of the people to live in the type of community that they chose to live in. They are then being deprived of the benefit of their bargain if they bought into the association because the documents said what they said. Those are sort of general issues. With respect to some particulars on the bill, I think it's problematic that there are intended to be 2 members of the legislature on this board. The reason being that later in the bill, we're told that decisions of this board, if not appealed, will be sent off to Superior Court to be entered as judgments. And so now we're sort of blending a bit what should be the different branches of government because we have legislators involved in a decision at a state-run board that then gets entered into as a judgment of the Superior Court ultimately at the end of the process. I think it's also problematic that within that process, that same board is not bound by common law or statutory rules of evidence. And so you have a proceeding that is not going to take place according to those rules. It's not going to take place with respect to the standards by which the court would handle evidence, and yet at the end of the day, the decision that's made will be certified as a judgment of the Superior Court. Another issue is that this is billed as sort of a necessary alternative, but with a $250 filing fee, it's slightly more expensive on day one than lower courts, it's only $25 different from filing in Superior Court. And in the same manner that a unit owner would be able to represent themselves before this board, they have the right to represent themselves, and often do. This is the area of law in which I practice. It's the only area of law in which I practiced for 19 years now. Unit owners often appear in court to represent themselves on a pro se basis. For most of them, I don't see that they have a problem expressing themselves to a judge any more than they would trying to express themselves to a 9-member board that they might be speaking in front of. So as an alternative, to the extent that that's supposed to be the basis or the purpose, again, I'm not sure that it succeeds. Again, with respect to specifics of the bill, the footnote, in particular, I'd like to mention, indicates that the financial impact to the state of New Hampshire will be indeterminable. So setting aside the notion of whether or not it's good to expand government and whether or not this is an instance in which it's really the best move to make to expand government, I think at this particular date and time, making a move that has an indeterminable financial impact on the state to solve a problem that isn't there in a way that isn't necessary just isn't good financial management for the state itself. Some of the particulars in the bill present, for me, some due process concerns. The Dispute Resolution Board is going to accept complaints from unit owners about their associations, but not from associations about any violating unit owners. Now, the same boards that we're talking about at these associations have a fiduciary obligation. In fact, this legislature, just a few years ago, put explicitly into the statute that these boards have a fiduciary obligation to their associations. Part of that obligation is to enforce the governing documents. And to the extent that, we're now having a state board come in and interfere with the condo board or the HOA board's ability to do that, we're really sort of creating a problem. And association boards, when unit owners are violating the documents, have the same needs to address that situation as unit owners who want to complain about their associations. In sum, the board, by design, based on what's written in the statute, is going to be a state-sanctioned one-way street. And I don't know that the state should be in the business of opening one-way streets when it comes to state agencies that will hear complaints and, supposedly address concerns of homeowners and unit owners in the state. Another issue I have from a due process perspective is that, according to this bill, an initial determination as to the merit of a complaint will be made prior to any statement being collected from the accused association. And that doesn't comport, as an attorney, that doesn't comport with the process that we always undertake, which is a two-part process. And for every complaint, there's an answer to the complaint. And for every motion, there's an opposition to a motion. So it's very problematic to think that this board would look at and pass judgment on the merits of a complaint, even in the first instance, hearing nothing from the accused association. I'll give you an example also of why I think that's problematic. Maybe make it a bit more concrete. I would suggest to you that in a vacuum, any complaint can sound meritorious and legitimate. And it's really hearing from the other side that affords any sense of perspective. I'll give you a true example that associations have dealt with. You might have a unit owner who complains that they went to the annual meeting in person, and at the annual meeting they were denied the ability to turn in their ballot and to vote. They feel that that is an affront of the highest nature to their most important right as a unit owner, their ability to vote as a member of the association. Now, in a vacuum, that sounds not only like a complaint of merit, but one that we should all be seriously concerned about. Yet, if we were to get even a small amount of information from the association, what we might learn, and this is the case for many associations, their documents require that in order for unit owners to be able to participate in voting at meetings, that they must be members in good standing. And good standing includes being up to date on all of your obligations to the association. And so the unit owner who was denied the ability to turn in their ballot, to the extent that they haven't paid, a condominium fee in 9 months, by the terms of their own documents, didn't have a right any longer to cast that ballot. And so what in a vacuum seemed like a highly important complaint, at the end of the day with just a simple statement from the association, we realize is more or less a non-issue. Because the documents at these associations say what they say, and they're intended to be covenants running with the land that everyone is required to comply with. So again, a due process concern there. There's some duplication of effort that concerns me in this bill. Towards the end, it's indicated that this board would fine associations that have engaged in discrimination. And I can't help but wonder as I read that portion how that doesn't either directly step on the toes of, so to speak, or at a minimum overlap, possibly in a confusing way, with the Commission Against Discrimination. In other words, the state Commission Against Discrimination already exists. They exist for purposes of handling complaints about discrimination, and I don't know why a new element of state government would be created and then be tasked with doing the same job as a piece of the state government that already exists. Turning to the HOA portion of the bill, I'm going to just quickly echo Attorney Feniger's comments that we're taking HOA provisions and we're more or less jamming them into RSA 477, which is not an HOA act. Now, a few years ago, there was a bill proposed to create an HOA act in the state of New Hampshire. It faded away. I'm not entirely sure why, but I would suggest to you that when it comes to governance of HOAs, it would make perfect sense to resurrect the effort to create an HOA statute. And I think that that should certainly be done prior to any cherry picking, which is what we see here when it comes to term limits and so on, of certain issues, and then embedding them into a different statute altogether. I think that should be handled through general legislation directed at HOAs. And I'm just going to close by saying that I know this quote was read to you previously, but the portion of the bill that says in print that the committee will favor the unit owner against the association when they're engaging in the decision-making and the process of looking into a complaint is really almost shameful. I don't mean to insult anybody, but it's shameful to me to think that in the state of New Hampshire we might have law in print which contains an explicit statement of bias that any state-sanctioned board is going to be making decisions on a basis that isn't objective, but rather starts out with an intention to lean towards one side or the other. It really just seems plain and simple to be wrong. And so for all of those reasons, I oppose this bill. I'm here again as the chair of the Legislative Action Committee of New Hampshire through the Community Associations Institute to let you know that as a committee, we have formally taken a position against this bill. I know that you've heard a lot from a lot of other speakers today. I would echo the points that they've all made and just ask that you allow condominiums and HOAs to continue to be governed by the documents that they're supposed to be governed by and not create additional and unnecessary state government.
Thank you. So this committee will note the fact that you think this legislation might need a little work. Thank you.
Thank you.
Michelle Lamothe.
He's going to have to buy us all lunch, I think.
Maybe it'd be dinner.
Maybe by the time we finish.
Yeah, yeah, exactly. Yep. Well, we've only got 5 more. And another bill, which is not going to take long, maybe. John Bisson? Well, Michelle? Good morning. We've heard a lot of testimony in opposition to this bill. I see that you're opposed to it also. We're asking our speakers to limit themselves to 3 minutes. We've heard just about everything negative with this bill at this point.
Okay. Can you hear me?
Yes. Please introduce yourself.
My name's Michelle Lamoth. I am the owner of a condominium in Londonderry, New Hampshire. I am also the board president of that condominium association, which is Rolling Meadows Condominium. We have 150 units. We were built back in the early 70s, so we've been around for quite a while. We've had, obviously, boards right along. I'm speaking today on behalf of the board. We do oppose this this bill based on how it's written. One of the biggest things that we see and we oppose is the fact that somehow we are supposed to get 150 unit owners to be on the board. You know, I did a little math with that. We have a 5-member board. That means 30 years worth of, or 30 terms worth of board members times 2 years. That's every 60 years you can be on the board. That doesn't make a lot of sense to me. That will never happen. It is extremely difficult to get anybody to run for the board. It's a lot of work. It's, you know, I'm up till midnight. I work full-time. Almost every other board member currently works full-time. We don't, we're okay with that. We don't mind putting in that work, but not everybody can. Not everybody has the ability to put in the time. Not everybody has the capability of being on the board. Some people can't manage their own budget, let alone, you know, a multi-million-dollar association. So it seems ridiculous to me and to our, you know, our other board members that this would be one of the requirements. And we've done all kinds of things trying to get people to run for the board. So that's one of our concerns about this. Another concern is item number 3, or what is it? No penalty shall be assessed on a property owner that encompasses greater than 30 days accumulated violations. Any penalty properly assessed shall be credited to the property owner to remediate the issue that caused the penalty to accrue. Any improperly assessed penalty shall be credited to the property owner. Property owners may seek restitution through the Condominium Dispute Resolution Board from the Homeowners Association. The fact that we would be limited to 30 days of penalizing somebody for doing something wrong, what do we do? How do we do that if they're continuously doing this wrong thing? You know, take them to court, sure, but that takes a long time. In the meantime, they're still doing things that are against the rules, that are affecting other association owners.
So we've, and I appreciate your testimony today. We're past the 3 minutes. I do, and this committee very much does appreciate you coming in and testifying today. We've heard numerous problems with this bill the way it is, and I hope you appreciate the fact that we'll be looking at it very closely.
I don't, I do, and I, very quickly, I'll just say in closing that it's not so much having a board for owners to bring disputes to, it's the way this is written.
Yep, we understand that. Thank you very much.
You're welcome.
John Bisson?
Good morning, folks. I'm John Bisson. I'm an attorney in Manchester, New Hampshire. I'm also a homeowner in a homeowners association, and I'm the president of my homeowners association, Courier Hill in East Manchester. Hello, Manchester people. I'm here unanimous. The lawyers you've heard from opposed to this. I understand 3 minutes. I'm going to be quick and hit it from high above. This is ill-placed from the get-go. 356B71, which is the first statute cited, says Condominium Homeowners Association and Cooperative Dispute Resolution Board, and it inserts it in 356B, which is the Condo Act. So what are we doing putting homeowners associations in 356B, which is specifically dedicated to condos? It does not belong there. If you want to create this board, it belongs somewhere else. As some of my colleagues who've already spoken have indicated, New Hampshire has no homeowners association law. There's no such statute. So in order to do this, you need to do that first and create that, because this legislation inserts itself in private contract rights. We represent a lot of developers, a lot of folks that build properties that people need to buy in New Hampshire, subdivisions in Manchester. One of the ways that they protect the value of those homes is they create homeowners associations that have rules, processes, protections. This inserts a body into that relationship and changes the rules, changes the written documents. I think there's a constitutional problem there. We have constitutional protections on the right to contract, and if a buyer willingly buys in a property, knowing what they're getting into, knowing that it's governed by an association, that's the deal. And putting something in there that says, as my colleagues have already pointed out, if you have a dispute, we're going to favor the homeowners. Bias, everything that Attorney DiDario said, 100% spot on, very eloquently stated. This legislation has bias drafted into it. It says we're going to favor those homeowners over the association, even though those people bought into that community knowing that there was an association to protect their interests. That's a problem. The other issue of bias that's in the legislation that I just want to point out is the statement that says any property owner who is subject to, in the view of the Condominium Dispute Resolution Board, an unreasonably delayed resolution to the dispute shall be entitled to proceed without further action or objection from the homeowners association. My first question is, what does that even say? If we had that kind of legislation in New Hampshire for our court process, let me tell you, every case would be thrown out in favor of the filing party, because what does it mean to be unreasonably delayed? This legislation, if you read it objectively, take a step back and look for all of those clauses and phrases that are in there that are not defined. Failure to follow proper voting procedures is a problem. Proper voting procedures. I don't think in this country we can come to a unanimous decision on what that even means on a national level. Let's put it into my 133 unit homeowners association and figure that out, because you're going to do that. You're going to have to figure that out. One final point, I know I'm running out of time. I am serving my third term as president of my homeowners association. There's a 2-term limit in my documents. Do you think that that's because I did a coup d'etat or something and forced myself on? No. It's because when I said it's time for me to step down, and I looked out at the audience of 65 folks in the room and said, who wants my seat? There was no eye contact. It's kind of like high school. All the kids, going like this. No one wanted the job. I don't want the job. Somebody's got to do it. If my neighbor wants to put a solar array in the front of his yard, our association documents wouldn't let them, because it doesn't belong there. Your legislation would allow them to do that. Thank you.
Thank you. And Peter Zofka. Peter Zofka. Zsofka. Hey. Could
Thank
you
you for listening
introduce
to me.
yourself and keep it to about 3 minutes, please?
Sure.
Thank you.
I'm Peter Zofka. I've been a condo and owner since 1985. I've had up to 80 units. I'm an investor. I just want to start off saying I'm against this bill. One reason is that I'm against it, and I don't want you to vote for it, is that some things, for example, in condominiums, time is of the essence, and if you take away condominiums, if you give a homeowner the right to be able to appeal something under this new board of approval for condos, it just prolongs a situation that, for example, I'll just give you one that I went through, cockroaches. A unit owner, a homeowner was belligerent and would not let the association get into the unit to treat for cockroaches. Fortunately, he caved in and allowed the association to get in and treat. Now, if he had a vendetta or was really knew about legal process, he might have said, no, I don't care, I'm going to appeal this, and that would have taken longer, in which case the cockroach problem would have been a little problem that turned into a huge problem. It would have infected more and more and more units, and you'd have more homeowners that would really be affected in a bad way by this. And then they would be outraged to go to the homeowner association, say, sorry, they just passed a new bill, blah, blah, and then you'd have these people calling up people, you guys, saying, hey, what is going on? You know, this is unacceptable. That's just one example. Against the term limits, too, for the homeowner association. It's a thankless job. I've been on a bunch. It's thankless, it's unpaid, and nobody wants to do it. It's not like the government where you're getting paid and there's a line of people that want to do this stuff. Nobody wants to do it. You're going to end up with association boards that have like 1 or 2 people on them. And then that's no good because, I mean, it just doesn't make any sense at all. It just doesn't make sense. And so I want to close saying that I'm against it, and I want you to know that I don't want you to vote for it. Thank you.
Well, thank you very much for taking your time to come in and speak to it. We appreciate it. The rest on this bill do not want, on this page, do not want to speak, but they're all in opposition to this legislation. We're down to the last few. We'd like to wrap it up. We have Sandra Morin in support of this bill. Is Sandra still here? Yes. Yeah, we're going to revisit this and, yep. Yeah, I think you're right. Not here? Yeah. That'd be great. So, who do we have? John?
Yeah, I am John Murphy. I have lived in the same mobile home park since August 1988, now known as Bearview Crossing Cooperative. I apologize for the makeshift booklets, but being retired on fixed income, this is what I can afford, not the fancy professional booklets put out by Rocky USA and Community Loan Fund. We are currently in a managerial default on our loan agreement provided in Section 1, as well as the notice of pending default. This was a result of the Board of Directors and Rock, New Hampshire for not following the bylaws and other policies that were put in place to prevent this. Rock, New Hampshire was supposed to train these board members to do their jobs properly and oversee meetings and read the monthly reports that were to be submitted. For almost 2 years, I just paid my rent throughout all this and was okay until the until the May annual meeting was canceled, and the excuse was that the annual audit was not completed. As of today, it still has not been presented to the members, and it was due May of 2021. I became concerned in July and made numerous emails to Chris Claspy and Alan Blake and CC'd everybody in the Rock, New Hampshire organization I could think of, as well as Foxfire Property Management in some cases. Back in August 2021, I kept asking about the condition of the loans being met, and either was told to ask the Board of Directors or, on the most part, never received a reply. The one time I asked the President of the Board if the annual budget for the year was approved, he stated yes. It could not have been approved as we had no annual meeting. It was never voted on by the membership. Why would I keep asking questions when the answers received don't make logical sense? This is why I went directly to Community Home Loan Fund in Rock, New Hampshire. We even went to an attorney when the pending letter of default came to see if it could be presented to the membership, because it was only sent to the Board of Directors. And as a member, I think everybody in the park should have known that we were in danger of going into default back when we could have done something about it. That was just a side note. The final issue I have is the annual report that is required by an RSA and has a penalty of perjury clause in it and due by April 1st of each year, was finally submitted late on August 3rd, 2021, and has so many incorrect numbers it is laughable. For instance, total expenditures is listed as $30,000 when the salary of the maintenance supervisor and also the president of the board, which is also a violation of the conflict of interest policy, is $65,000 a year. When this and the failure to provide the audit on a timely manner was brought to the state's attention, I was told that there are no penalties and that they are not an enforcing agency, see Section 5. As you can see, we need some type of legislation which will hold boards accountable when bylaws and policies are violated or not followed. If there were, this default of the park of 300 homes may have been avoided. Thank you.
Thank you, Mr. Murphy. Appreciate your testimony today. We'll look at your packet.
Thank you.
Is Sandra here? So we have Sandra and Louise. Would you like to testify together?
No, I'm going to testify with her after.
Okay.
She's the one who wants to have her hand held.
So you are Sandra?
I'm Sandra Morin. I've been living there for 6 years, and I am reading this for someone else who didn't want to come in and read. It's my neighbor, okay?
Great.
Yeah, she's outside. She lived there for 16 years, and she has been trying to have a problem fixed with her motorhome, her trailer, because she is sitting on a swamp. And they did not put a slab. And what happens is she's got mold growing in her house. Her doors don't close. Everything's going crazy. So the president said, oh yeah, we'll take care of it, we'll take care of it, we'll take care of it. Never did. Her front driveway is full of water. The water goes across the road and ends up in somebody else's house. And what they did is they dug up the ground and they put these big pipes, and the pipes go on to other people's houses. Well, now they've allowed, the president allowed somebody to put a house next door to her, and they put 2 big pipes because she's got like a underground spring, and it's dumping underneath her house. The woman is older and she's getting sick. And there's nothing we can do about it. It's your problem. So what are we supposed to do in a situation like that? I mean, 2 pipes, and you can see he put the pipe so that it was just sticking out, and you can see it's just going on everywhere else. She says right here, to make things worse, they allowed someone to build next door, and they have 2 drainage pipes that go on her lot. It's very discouraging for her to hear the promises and to never get anything fixed. Like I said, her doors don't close. She's got crown molding that's coming apart everywhere. She's got mold growing in her house. So what do you do in a situation like that? I mean, how did she get this taken care of when they knew that we were in a swamp area? There's 2 roads that are like in a swamp area, and we always have water problems. At one time, I owed $2,400 for water because I told them there was a leak and they didn't do anything. So finally, after 3 meetings and 3 calls, I called and I said, tell, Robin, he needs to come see me. Yeah. So when we went to a meeting, I finally said, when are you guys gonna do something? And she says, well, you need to call us. I called you 3 times and you never did anything. So, it's crazy.
Yep.
It's really crazy what's going on. But this woman here, I feel bad because she's in her 80s? 87, and she's dealing with this. She's afraid to go out in her driveway because she's gonna fall. She can't close her doors. Mold is bad, so we're just trying to get somebody to help us take care of these problems.
Great, thank you.
Yeah? Okay, next.
Bonnie?
Okay, I'm gonna stay here.
Sorry. Good morning. First, I'd like to thank all of you for being here today to listen to us. My name is Bonnie Corries, and I live in Bearview Community Co-op in Allenstown, New Hampshire. I am a widow of a Vietnam veteran. I bought this home in June 2020, and I used the money that the VA gave me after declaring my husband died of a service-related injury. I bought this thinking I was going to have this be my last home and I would be able to live in a great community. Sadly, that has not been the case. In January 2021, I applied for a vacant position as secretary on the board of directors with the intent to help the co-op and its members as best I could. However, again, I'm saddened to say I soon found out that a lot of things that were being done by the board were not according to the bylaws set forth by ROC. Meetings were all held as private, not allowing members to attend, and most importantly, the president and the treasurer were running the co-op operations as they saw fit. For example, in February, there was a Zoom meeting with Kelly Cicerelli. In that meeting, she mentions that the president should not be sitting on the board of directors because he was also employed by the park. And much to my surprise, I found out that the president had given himself and 2 of the co-op employees, one being his son, which is a conflict of interest, $6,000 in Christmas bonuses without member approval, and spent $30,000 on tree removal, again without member approval. During that Zoom meeting, Kelly Cicerelli told Robin, the co-op president, and I quote, I know it was wrong for you to give out those bonuses and pay for tree removal without member approval, and you know that I have spoken to you
Bonnie,
before.
excuse me. Any testimony you pass in, such as this, please don't read it to the committee. We'll read that. Could you just testify?
Oh, okay, this is just my opening statement. I gave you a copy of that as well.
Yeah, we have that.
Okay.
So we will read that.
Oh, okay, so you don't want me to go, okay, all right.
Yes, so just tell us briefly.
Okay, the only other thing, you can read that. The only
Yep.
other thing I do want to say is when I bought this home, the home was sold to me illegally. I am living in a home that does not have an occupancy permit, that no building permits were done. I lived there last winter. I turned on my furnace blew up. I was breathing black soot. Come to find out, the furnace had not been transferred from natural gas to propane. So that's when I went down to the building inspector and I asked him, and he said to me, because of COVID, we can't have you move out. You're not supposed to be living there. So I went to the board of directors because the home had a 1-year warranty, and they passed that they would pay the $5,000 for me to have the furnace replaced. After that approval, the president of the board turned around and changed his mind and did not allow me to have the park to pay for it. I had to take out a second mortgage to pay for that. Right now, my slab is, my whole slab is up off the ground like this. My whole house is twisting. I'm at a loss. I did go see an attorney. The attorney did tell me that I have a lawsuit against Community Home Loan Fund because it was their responsibility to ensure before they gave me the mortgage that there was an occupancy permit, that the house had been inspected. When I brought all this up to the board of directors, because the person that sold me the house was the board of directors, because it was owned by Bearview Community Co-op, they told me that they no longer in New Hampshire inspect mobile homes. They just, brand new, they just sell them like that and you just wing it.
So where's your park? Is it down in Allenstown?
It's in Allenstown.
Behind Bywise, that
Yes,
area?
exactly, yes, Sully's
Yeah,
now.
Sully's, okay.
Yeah.
You're giving your age.
Yeah, right?
But it-
Yeah, I'm old. I'm very old.
Me too.
Yeah.
My point is, we can't get any resolution from the board of directors. We can't get any help. We have a new board of directors who does absolutely nothing right now to let the members know anything. It's awful.
Yep.
This woman, my house, I was just told now, I can't sell my home because there's no CO and it hasn't been inspected. My homeowner's insurance, if my house burns down or anything, my homeowner's insurance will not pay because my house doesn't have a CO.
Yeah.
I'm paying a mortgage for which my escrow account was $35 or $40 short because the taxes went up. I just got a bill from Community Home Loan Fund charging me $45 because my escrow account was short. But when I called them, they said, well, we're going to do you a favor. We'll only bill you $3 a month until the $45 gets paid up with interest.
I appreciate.
I have no recourse. You need to pass this bill. The people that buy in these parks need to be protected. We have no recourse. So whatever you can do to try to help us out. would be
That's
great.
what we're working on. Thank you
And
very
I'm sorry I
much.
cried.
No, that was good.
She didn't cry, but she was shaking a lot.
Thank you.
Thank you. Is Louise here? Louise Rideout? Yep.
I do have some packets too. Some emails. There's a couple that don't have emails. I'm very sorry I didn't get to print them all out. I just want to thank all the sponsors, Senator French, Senator Carson, Senator Susie, Senator Ryan, Senator Gannon, Senator Sherman, Representative Gordon, Representative Almy. And Senator French, I want to personally thank you because you took a phone call from me on a Sunday morning. And I was like amazed. And I really thank you because you really listened. You really let me speak to what I had to say. My name is Louise Rideout. I live at 34 Roland Drive in Allenstown in Bearview Crossing Cooperative. And why do we need a dispute resolution board? Well, there's a few things that I feel like if I share with you, maybe it would bring light to more situations. The members, we're owners, we're taxpayers. Most of us are voters. And there's a lot of people that are afraid to come because of retaliation. And we were pitched, the sales pitch, I believe, by Community Home Loan Fund. That's how I felt, because I bought in October 2018. The park went up for sale. If I had known, I might not have gone that route. It's not that I'm against residents owning it, but the way this was pitched to us by Community Home Loan Fund was really bad because we're low income, low to moderate income, and fixed income. So there was a big sale back then, 3 years ago, with that big $48 million. So it seems like Rock and Community Home Loan Fund knew about it from the beginning, and they really influenced a lot of the people that first called meetings at our co-op, and they became like the first board of directors. And they were right there with the Community Home Loan Fund representative who was, is it okay to say her name or should I not say her name?
Sure.
Michelle Supri. So in the beginning, she pretty much ran every meeting, kind of strong-armed us into everything that we had to do. And when I say this, we needed, every co-op by Rock standards has to have a management company. So Compass Management was just being formed, and Joya Hughes, who was a former Community Home Loan Fund employee, Michelle Supri strongly recommended that we hire them.
We are currently in a default since October 2021. And it has, I'm not sure, but I think it has been extended. So this default was issued by the Community Home Loan Fund. So it's hard to be on this side of this situation because I have corresponded with them more than 100 emails to Chris Clasby, Alan Blake, Tara Reardon, Kelly Cicerelli, Steve Saltzman, and most of the time I get no responses. We had a meeting in November, first annual meeting, because everything was put off because of COVID, and so we had a board of directors that run rogue. They do whatever they basically want to do. There's no accountability, there's no ethics, there's no rules and bylaws followed. So our lender at this meeting, Mr. Clasby, spoke and told us, because our audit for the first year from 2019 to 2020 was completed, he told us at this meeting, he stood up in front of all of us and told us that the auditors couldn't reconcile over $150,000 that they were having trouble reconciling. And, I mean, my mouth fell open. I knew there were problems, but to this extent, I didn't realize how bad it was. So he spoke a little bit, and by the end of the meeting, he tried to say, well, maybe it's only $30,000. It might have been because you're a new co-op and you have bad bookkeeping.
I hate to cut you off, but we're running into
Okay.
a deadline.
So can I just,
Yep, if you could just.
with the lenders, I do believe that if we don't have a dispute resolution board, the lenders are walking all over us, and they're supposed to be nonprofit, they're supposed to be helping people in our situations, and I feel like they do not do that. When they secured the loan, they charged us $270,000, 1.5% of the interest of the $18 million. And I feel like that's a lot of money to put onto low and income and fixed income people. And then I heard that they hired a lobbyist, and I was just curious, who's paying for the lobbyist for a nonprofit organization? And I've also done research that they have received HUD grants for over $500,000. But our park can't even get answers from them ever. And we get treated with such disrespect that I really hope that this bill passes, and whatever else we can do, and I can do personally.
So if this doesn't move along, just be in touch with me and we'll see what we can do through existing agencies. Senator Bradley?
Can you outline what you just said about the 1.5% fee? Who got it and who paid for it?
Okay, that is part of the acquisition in the paperwork there. And the acquisition shows that Community Home Loan Fund charged us 1.5% of the purchase price, $18 million.
Of the entire co-op?
For that one co-op, for our one co-op, not for the others, because I think they got one other one and then the other one didn't pass for them. So that was $270,000 that we have in a loan.
That
Our
your
loan-
members paid for the
That's
purpose of
included in
getting
the
the
loan.
loan?
Plus, we pay a $7,000 to $8,000 a year technical fee for a Community Home Loan Fund to be helping us. And there is one email in there that says, well, why weren't you helping us all along? How did we get to this point? This agency Community Home Loan Fund should be investigated, because I do not think they're helping people.
And I believe, if I don't mind, I believe there's a lot of predatory lending. They say they give mortgages to low-income elderly people. I'm paying almost 9% interest on my loan. That's a lot of money for someone that's 69 years old. And the majority of the people like you, and we're all, a lot of us are senior citizens. That's a lot of money. That is a big interest rate.
And we have also mentioned about possible embezzlement, because mismanagement of funds. We have gone to so many different places to try to get help with it, because it could possibly be criminal activity. Mr. Clasby told me on the phone that, I said, what do you do if there's wrongdoings? He said there could be prosecution, there could be restitution, there could be jail time. And I think there's really important, and he didn't want to sign off on the audit, so this is really
Yeah.
serious. I really feel like if this bill doesn't pass, can you please send us help our way? Because we need some kind of
We do,
resolution.
especially with this audit. Mr. Claspy wouldn't sign off on it, but from what I understand, he had the newest president of the board who doesn't know.
Yeah. Thank you very much. I
thank you
appreciate
very
your
much.
time.
Thank you for listening, I
Have a
really
great
do.
day.
Thank you.
And lastly, we have Susan Mata. Right, so anyone else looking to speak, sir? I didn't see you on the list. Would you like to speak? Come on up. If you signed on the list, come on up if you'd like to speak. Certain people didn't put whether they wanted to speak or not, so I didn't call on them.
I have all day, nothing to do and all day to do it, so. My name is Tom Tessier.
Yep, saw your name.
I'm a native and lifelong resident of New Hampshire, a 5-tour Vietnam vet. And while sitting here, my hearing aid batteries died, so I think I heard you say there was a time limit?
Yes, 3 minutes,
3
please.
minutes. Oh, well, I got 25 pages of notes. All right, I'll cut it down. First of all, excuse my attire. I'm in mourning. The Patriots and Buccaneers didn't make it to the Super Bowl.
I don't blame you.
And I just got a text, Tom Brady is officially retired.
No. Oh,
Just got a text.
end of meeting.
End of meeting. I've owned 3 condominiums.
I know.
I've owned 3
No.
condominiums. Hello, am I still here?
Yes.
I've owned 3 condominiums, one in Hebron, one in Bridgewater, and I live at the Hayden Green condominiums in Nashua, New Hampshire. I didn't want to be on the board, but they couldn't find anybody else, so I allowed myself to go on the board as a member at large, so I wouldn't have any responsibility. But I've actually found it to be a lot of fun. I'm totally opposed to this bill for a number of reasons. You've heard them all. We've only had one issue in my 38 years on these different condo associations. One issue came up when one morning a bunch of pink flamingos showed up, and the person said that they were decorations and they were going to stay there. Well, we took care of that because we had documents that said you couldn't do that, and that person never read the documents. So it wasn't a big deal. The 2-year term thing that was discussed is absurd, as you probably heard. It's impossible. The solar panel issues were mentioned. The favoring complainants is very prejudicial. Those were all the points, some of the points I was going to make. I think if this bill passed, that our board of 5 would probably all resign. Wouldn't make any sense to stay on because we wouldn't have any control based on our documents because somebody else would be telling us what to do, so it wouldn't make any sense. Last thing I'll say is why fix something that's 99.99% effective already? The system is not broken. If you get one complaint out of 100,000 or 10,000, whatever that number is, it doesn't make sense to set up another bureaucracy with all the costs attributable to that bureaucracy. And lastly, I'll say, I admire you guys for your patience, and you too. You're very patient people.
Well, you were the patient one for waiting so long to testify. We do appreciate it
I was wondering
very
what the heck was
much.
taking so long. Thank you.
Bye now. I'll close this hearing on Senate Bill 324, and we'll open a hearing on Senate Bill 211. Ta-da! With our patient Senator D'Alessandro. Donna, what time did you have to leave? Noon? Yeah.
Oh, man, I gotta say this. Senator French, one of the great privileges of this life.
It's unbelievable.
Coming before your committee.
Thank you, sir.
You know, the thrill, I waited 2 hours for this moment.
You know,
2 hours in waiting.
I put in a piece of legislation, I sponsored it, that had a little opposition, shall we say.
Well,
It's wonderful to see all of you. A lot of power behind that desk. Senator Soucy, Senator Kavanaugh, Senator French, Senator Gannon, Senator Bradley.
Oh, he's still here?
He's here. Mr. Chairman, thank you for the privilege of coming before this committee. For the record, I'm Senator Lou D'Alessandro. I represent District 20, Manchester Wards 3, 4, 10, 11, in the town of Goffstown. And I come before you as the prime sponsor of Senate Bill 211, an act relative to an injured employee's right to reinstatement to a former position for the purpose of workingmen's compensation. John Sullivan was here, but had to leave, and I have his testimony, and I want to enter it into the record. So if you want me to read it in, I will, or if not, I'll just give it to you.
Just pass it in, that'd be great, Senator. Thank you.
Thank you, Mr. Chairman. I want to be very, very brief. Obviously, finding employees is extremely difficult in this environment. And what this bill adds is an exemption to an employee's right to reinstatement to his or her position based on the employer's need to fill the position where a temporary replacement is not available or practical. A, we know how difficult it is to find employees. B, when an employee leaves and you have to replace that employee, that in essence is pretty difficult also. But if you do, because of the need, it becomes a very difficult situation, and this deals with that situation. Small businesses do everything possible to hold a job for an employee who's out on workingman's comp. Unfortunately, being out for an extended period puts an undue hardship on the current employees as they become burnt out and some leave, which creates other hiring and retention challenges for small businesses. I think it's very clear to you what the situation is. You lose a person, you try to replace that person. If you do replace that person, retaining the position for the original person is quite difficult. Puts you in a very, very difficult situation. And there are jobs where they're very particular in terms of the employment category you're in. For example, a sheet metal worker or something of that nature. You lose one, very difficult to find another one, and that's why I've introduced this piece of legislation. Now, I understand, and I tried to do some research on this, that in the 1990s, I think someone said to me 1993, 1994, some kind of a compromise was drawn to a piece of legislation quite like this one. Now, that was before I came back to the legislature. And I tried to follow up on it by calling Dave Wibby, who was the deputy commissioner at that time, but I couldn't reach him. He's changed his phone number, and I believe he's in Florida. So I don't know anything about this grand deal that was constructed. I have no knowledge of it. Tried to do some research on it, but it didn't come. So I think you know quite specifically why the legislation has been brought forward, what the problem is, what the solution is to it. And I think in this world where getting labor is extremely difficult, and if that person has a particular job specificity, it's even more difficult. So I leave you with that thought, Mr. Chairman, and thank you very much for the opportunity to come before you.
Thank you, Senator. I'm sorry you were delayed so long. Any questions from the committee? Seeing none, thank you very much.
Thank you. And I'll give this to the clerk.
Great.
Please excuse me, I have to leave because I have a committee that I have to do.
I hope you weren't waiting that whole time. Danielle Albert?
Good morning. I'm Danielle Albert. I'm the director of the Workers' Compensation Division for the New Hampshire Department of Labor. I think everyone's had a long morning, so I'll try to be as brief as possible. The department's here just to give a little bit of context about the benefit itself as it currently stands within the statute, a little bit of information about the department's interaction with this particular benefit and what ways it comes to our attention and in what contexts, and then to make just one technical suggestion relative to the language that's been proposed today. In general, when we're looking at this particular benefit, reinstatement is a benefit that's available to injured workers under the workers' compensation law. And what it does is it provides a mechanism by which an injured worker is able to return to their job of injury following a compensable work-related injury. And it's a benefit that's unique one in the sense that it's between the employer and the employee. The insurance carrier is not providing this particular benefit. And one of the unique things that comes up in the context of that benefit is it does create a vehicle by which employees and their employers continue to communicate with each other in the context of getting this benefit into place when it's needed. So we do believe that that's an important thing to be cognizant of, and it is a unique benefit in that context. It puts them in a position to talk and communicate with each other over the course of an injured worker's injury. Relative to the department's interaction with this benefit, we do receive calls primarily from injured workers, mostly looking for information about what is it. Is there a way for me to get back to my job of injury? Am I able to ask for that? At which point the department will provide technical guidance on what the requirements are in the statute, let people know that they can ask for that and what to do if a dispute arises. The lesser interaction that we have with it is in relation to disputes themselves. They do arise, I would say, occasionally when we're looking at the gamut of types of disputes that might come forward in the workers' compensation system. And when those are presented to the department, we provide the mechanism by which the disputes can be litigated and determined. When the benefit is being provided, when the injured worker is working with their employer or reaching out to the employer to have the benefit, we would have no way of knowing if it's in place. There's not a reporting requirement by which the parties are then going to come back and tell the department this particular benefit has been provided to an injured worker. As far as the language that's in the proposal itself and relative to the department's technical suggestion or comment that we'll have on it, the language that is being proposed is putting forward or amending Section 2 in 25A2 to add an additional criteria for, as we understand, that would terminate the right to reinstatement. That language begins with the phrase, the employer determines that the employee position must be filled, and a replacement on a temporary basis is either not available or practical. When we're looking at Section 1 within 25A, there is already a definition in the existing law that defines what is available, and that language is to the effect that a position is available even if the position has been filled by a replacement while the injured employee was absent. So we would have, or would suggest, perhaps looking at that language if this were to pass, that could create some conflict or confusion relative to what actually makes a position available. Currently, there's a definition. If a position is filled, it is still considered available under the existing law. If this amendment were to go in, it looks like there's some discrepancy or some conflict amongst the language about what would make a position available relative to reinstatement. I'm happy to take any questions if there are any.
Thank you. Questions? Senator?
Thank you, Mr. Chairman. Is there any time limit right now? So I'm hurt at work. Is there something that my employer has to hold at a certain amount of time right now?
In the work, do you mean in the workers' compensation context?
Correct,
Yes, that's an excellent question. If you look in the statute itself, already in Section 2, the benefit is one that's available to an injured worker for a period of 18 months from the date of injury itself. So there is a time frame that's already built in. That 18-month time frame is exceeded, then it's one of the already existing reasons why the benefit may cease to be available or end.
Follow-up, please?
Sure.
Thank you. So if I'm 19 months and some injuries I've seen where you're going to be a couple years out, so that employer is free to let that employer go? The employer is free to let the employee go after that time frame?
It's also an excellent question. So I do think that there is a distinction between letting an employee go. The statute as it currently stands, as well as all the other provisions within the workers' compensation law, don't have requirements that an employer must terminate an employee or anything of that nature. The right to ask for reinstatement and have it as an available benefit it's time limited, so that would cease to exist. There are other benefits that would still be available to an injured worker if an employer didn't take actions or steps to terminate the employee-employer relationship, inclusive of temporary alternative duty, which is a different benefit available under the workers' compensation statute that also assists injured workers in transitioning back into their job of injury. That is a separate and distinct benefit. It operates a little bit differently, but it's not going to necessarily, I would hope that it would not necessarily result in the 18 months is up and employment is now terminated. That's not a requirement in the statute. The employee would lose the right to come forward and say, I'm asking for it, I'm now entitled to it because the time frame in which to avail themselves of the benefit is ended.
Thank you.
You're welcome.
Thank you.
Thank you. Thank you very
Thank you.
much. Jared O'Connor?
Morning, Mr. Chairman, members of the committee. Thanks for hearing us today. So my name is Jared O'Connor. I'm a partner at Shaheen & Gordon, and I practice exclusively in the realm of workers' comp. I represent injured workers and have done so now for about 20 years, and that's about all I've done. I'm here to testify against or to recommend opposition to this bill. You've already heard the director talk a little bit about what reinstatement is, but I'm going to try not to overlap too much, but I want to summarize from an injured worker's perspective what this law has been doing for the last roughly 30 years and why, in my view, it's been working well, and I think there are problems that will be introduced by this legislation. So under current law, as you've heard, an injured worker does have the right to be reinstated to his or her job upon request if the position is available, and that's been defined as even though it's temporarily filled, they have the right to be reinstated to that position. This obligation on behalf of the employer only exists for larger employers. If you have 5 or fewer employees, then you're exempt from this requirement, so it lifts a little of the burden on the smaller businesses in the state. From the injured worker's perspective, your right to reinstatement terminates if one of 3 things happen. First, your treating doctor determines that you can't return to the job. So that's one automatic termination to the right to reinstatement. The second is if the employee accepts a job with a different employer. And the third is if 18 months elapse from the date of the injury. I think the thing to be aware of when you're looking at those 3 factors that terminate the right is that they're all externally determined except for the employee, by which I mean the employee decides to take another job, right to reinstatement's over. 18 months have elapsed, the right's over. Or if the treating doctor says, you're not going back to this kind of work, the right is over. What this legislation does is it gives the employer, for the first time, the right to unilaterally terminate a claimant's right to reinstatement. And so I think that's a problem because what the legislation says is if the employer determines that it must be filled and a temporary replacement is not available or practical, I think that's a wildly subjective view. It's an employer-sided standard that I think is subject to abuse. And I mean, I think it effectively wipes out the right to reinstatement for injured workers. If you think about it, a temporary replacement for an injured worker is rarely going to be practical. But this right to reinstatement has now existed in place the way it is for almost 30 years, and it's been workable. As you heard the director testify, very few of these kinds of hearings or disputes between employers and their employees come before the department. And that's been my experience as well, having now done this for, as I say, 20 years. I can count on one hand the kinds of hearings that we've requested at the Labor Department to force a reinstatement or to argue about reinstatement. So yes, it is impractical for employers to temporarily fill a position when an injured worker is out. So that's a slight burden on the employer, there's no doubt about it. But injured workers also assume a slight burden by being out on comp and getting 60% of their wages while they're trying to heal and get themselves back to work. And that's generally how I describe this to my clients, is to say, listen, when you're injured on the job, what happens is the insurance carrier steps in, pays for your medical treatment, gives you 60% of your wages in the hope that you'll be able to recover to the point where you can go back to your job within 18 months. And if you can, great, your relationship with your employer is still there, you can go back. And if you can't, you can't, and that's the end of it. But that's the system as it's been in place for about 30 years now. And it's also worth pointing out that in most cases, this burden on the employer doesn't last for 18 months. So I don't want you to have in mind that they have to hold this temporary position for 18 months. That's usually not the way it works. Usually the way it works is someone's injured, they get treatment, they're back to work within a month or 2. Once they're back to work, obviously the right to reinstatement, no longer an issue. Or they're really, really seriously injured right away, and it becomes clear immediately this person's never going back to this kind of job, and under existing law, the treating doctor says you can't go back, right to reinstatement's over. So because under current law, the ways in which reinstatement terminates is so clear, that's the reason I think this should stay the way it is. I think because of that, it's very rarely litigated, as I say. I think a consequence of this bill would be to encourage litigation, because what you'd see is employers filling the position, wanting to make the argument that it's not practical to fill it on a temporary basis. If that were to happen, the injured worker at that point has incentive to litigate, to bring the case back before the department, to argue that their position should have been held or that they're entitled to go back and replace the temporary replacement, and that it was, in fact, practical to hold that position. The reason there's some incentive for them to do that is that if the employer is found to have inappropriately terminated the right to reinstatement, the injured worker is entitled to get wages directly, full wages directly from the employer under existing law. That's not something I think that would foster the kind of cooperation between employers and employees that this system was designed to do. I mean, reinstatement is the rare circumstance, as I think the director also mentioned, where the employer has a stake in the process. For the most part, workers' comp litigation in particular is between the insurance carrier and the injured worker, and the employer is off on the sidelines. And to the extent the injured worker can go back, then they can go back once they're able to medically return. But they don't get dragged into the Labor Department for hearings. I think this legislation would change that. I don't think that's a great idea. So I think the system is working. I think it would be very disruptive to introduce this new employer-sided option of terminating the right to reinstatement. So that's why I oppose. Thank you very much.
Thank you.
Any questions?
Yes, Senator Susie.
If I could, so if this law were to pass and the employer declines to reinstate, doesn't that, in essence, sort of swallow up the other provisions that are currently the right of the employee? I mean, because as I read this, the 18 months is potentially in question because the employer could determine that in 3 months they're going to terminate. So in essence, doesn't this, beyond just changing one term, affect the other three that are currently a right of the employee?
Sure. I mean, any of the three existing provisions that terminate the right, terminate the right. So if the injured worker's doctor says you're never going back to this kind of work, the right to reinstatement is over on day 2. You know, if you've got an iron worker who fractures their pelvis, it's immediately clear this person's never going back. There is no right to reinstatement, and the employer can hire someone else right away on a permanent basis. So if a fourth factor were to be introduced that says the employer has the right to terminate, then yeah, the employer could terminate on day 2, and there is no more right to reinstatement. So I think that's correct. And I think that's the reason why it would encourage injured workers to want to litigate that issue, because then that same person who at month 4 is able to return to work, wants to go back to that job, they have the option of hauling the employer back to the Labor Department for a hearing on this question of, well, was it really impractical for you to fill my position? And that's not the kind of thing that's happening now at the Labor Department.
And if I may, so this would also discourage that sort of communication between the employer and the employee about the employee's potential to recover.
I think it would, and the way the system works now is the employee is encouraged to stay in touch with their employer to let them know, here's what my restrictions are you able to take me back on a temporary basis with accommodation, or I'm progressing, my doctor says I should be able to come back full-time in about 3 weeks. Great, they all stay in touch, and it keeps that communication open between the two.
Thank you.
Thanks.
For those of you who might be here thinking we're going to be execing today, we're not. We'll be execing most of the bills next week. So just wanted to let you know. Last speaker is Jerry O'Neill.
Thank you, Mr. Chairman. Thank you for the opportunity to talk to you today. I am Jerry O'Neill. I'm considered a senior partner at my law firm in Laconia, New Hampshire, because I've been there 42 years, going on 43, which means that I have had the experience of practicing workers' compensation law both before and after the right of reinstatement was created. So I'd like to give you just a little bit of context for how we got here. And I'm here to speak, so it's clear, in opposition to the proposed legislation, because I believe it returns us back to where we were for the first 15 years of my practice. Under prior law on the issue of job protection, the injured workers, it was an entirely one-sided position. The employer had all of the power. There was no responsibility on the employer to keep a job available for an employee and or to accommodate that employee, to help them get back to work. And if you read this statute, it has with it a right to return to work within 18 months. It contemplates that the employer will have to cooperate and help get that person back or accommodate them to get them back. That's new. That's something that never existed before. And as a consequence of that prior law, in my experience, a majority of time, anytime there was a significant loss of time as part of a workers' compensation claim, what was coming down the pike for that employee was not only the loss of income for the time they were going to be out of work, but they were going to lose their job. And any benefits that they and their family were entitled to would go with that job. In addition, having represented employees for 42 years, there is a devastating impact on employees when they lose their job. There's a commitment, a personal affront almost sometimes when they're terminated. Now, you can still terminate under this current provision. It's just that if your employee recovers sufficiently and with some help can get back to their job, then you have to reinstate them. So the termination part still exists. It's just you have to keep in mind, and that's where the communication that everybody else has been mentioning to you takes place. The communication, the idea that this person may be coming back keeps a connection. And that's important because under the former law, once an employee was terminated, pretty much the employer was done with them. The problem would exist is that then to fill that breach, the system had only a new employer who had no commitment to that person, who had no responsibility for the injury occurring there, and who had certainly no responsibility to take on the accommodation of accommodating that person to get him back to work. It was a difficult, if not impossible, task for those 15 years to find new employers. There was tons of money spent on vocational rehabilitation and still failing. So that was one of the concerns. At the same time, we were hearing on our side of it, the workers' comp carriers and employers were feeling that the cost of the system in the early 90s was out of control. And the reason they were, one of the reasons they believed it was out of control was because of the belief on their part, something I wouldn't necessarily agree with, but the belief that injured workers were staying out longer than their injuries were required. And some of that was related to the problem I just discussed, couldn't find work. So they were saying that there was an excessive cost. And what happened in the early 90s, 92, 93, I was on the trial lawyers board, and all of the parties that had interest in this, employers, unions, workers' comp carriers, got together and hammered out a deal. That deal resulted in one of the benefits being the right of reinstatement. Temporary alternative duty came with that. There were some other changes, managed care. If you look at, I don't have the legislative history, and I'm a little old to remember it all, but I know what the issues were. And the issues were, how were you going to bring down the cost reasonably? How are we going to address the idea that employees need a place to go? But also, small business. How can you expect a small business to take on this burden? As Jared explained the burden very well. There's a burden on the employee. They're losing 6 to 2/3 of their benefits. Back then, it was 66 2/3. The burden on employers was considered, and if you look how this law is structured, small business is exempted out because that would have been too much a burden on them. Okay? not all employees are entitled to the right of reinstatement. But the compromise that was worked out was if you met certain criteria, then the unlimited discretion to terminate employers had was modified. It was limited by the 18 months, by the person's ability to return to work, by the employee taking another job, but they couldn't just terminate at will if they were big enough under the system, from the system's point of view, to handle this minimum right that was being given. And I believe, as you've heard, it's worked pretty well. I mean, there haven't been a lot of hearings. I do not quite as much as Jared, but I do a fair amount of comp cases and probably 4, 5, 6 hearings. It is because this process requires the communication that was cut away under the old system. And it's important to keep in mind that this was not a gift to employees. Employees at the time, all employees in the state, some of who didn't benefit from a systems point of view, exchanged 6 2/3 of their comp benefit to get this right of reinstatement. That's part of that grand bargain. This was a bargain for, in a system-wide basis, benefit. The current proposal basically represents a return to the prior standards, and it places all injured employees at the risk of termination based on a subjective standard. The standard is, at the beginning of the provision of this law, it says, the employer determines. That is exactly where we were for the first 15 years of my practice. The employer would determine the fate of the employee's job, no matter what level of employment, whether there was a large employer, small employer, one person. So in my humble opinion, I would submit that this guts reinstatement. And it does so, most importantly, without providing employees with anything in return, which is contrary to the underpinnings of the workers' compensation system, which is that immunity is the first and easiest one. Employers get immunity, employees get a specific set of benefits. And that concept is that the common law doesn't work so well in a workplace that has to keep functioning in the face of inevitable injuries. And so that employers and employees come together to make or exchange rights, what it comes down to make the system better, to work and function better when the inevitable injuries occur. If you are going to unilaterally take away a right that was, I think, pretty clearly bargained for as a system, in the system at least, then it would only be fair to return to the employees 6 2/3% benefits. And I don't think anybody's going to say that's a good idea. I could tell you that I represent a lot of clients where, on an individual basis, the people who don't have that right of reinstatement would be far better off with 6 2/3%. I can tell you when I compare 15 years of practicing under that old system to 26, 27 years under this new system, as a whole, the system works better because there is a communication between employers and employees. There's less animosity. There are a few times where you have to litigate issues, but not a lot. And that works to get people back to work sooner. It's good for carriers. I think, in fact, if you have a reinstatement hearing, what you will find is that the employer is given a separate notice from the insurance carrier. It's the only place in the whole system where that happens, or at least the only one I've experienced. And they're told to get their own lawyer because workers' comp carriers want that right of reinstatement. They want it to be enforced because it does work in keeping the costs down, which is good overall for the business climate of the state. So I would say that as you've heard for the other two speakers, based on all of my experience, that this system does work, and taking that benefit away from employees, especially in not replacing it with something that they had before, would be unfair and would be not effective. It would affect the efficiency of the system negatively. Thank you.
Thank you.
Any questions?
Seeing none, thank you very much for coming today. Anyone else here wishing to speak on Senate Bill 211? Then I'll close the hearing on Senate Bill 211, and we will adjourn. Opened up a can of worms with that one. Well, you know what I did.
I knew that the last 2 days.
I know, everyone who hasn't.
This is an amendment for next week.
You have an idea.
Okay.
Sarah
Must be good then. I'm Marissa. How you doing? You living the dream? Good, good. What's that? On which, with the condo one? Oh, this one? No, geez, I'm still back on the condo one. The 200 phone calls for all the condo one. Oh.
Save me on that condo one, will you?
We're gonna just get rid of that.
We're gonna come back with something new. and
No,
improved.
no, we're just gonna, no, next year, right?
Yeah,
Yeah, just ITL this.
No, no.
Yeah.
Intro study.
Yeah, there you go.